Here. Mr. Ekman.
Here.
Dr. Lazarchuk.
Here.
Ms. Laredo. Ms. Shefelt. Here. Dr. Sullivan.
Here.
Dr. Warner.
Here.
Dr. Waterhouse.
Here.
We have a quorum.
Great. May we have audience introduction, please?
Ben Pulowski of CBMA. Brad Miller of CBMA.
Valerie Fenton-Maker, CBMA. Bonnie Lou. Alina Levy, President, California RBC Association. Cynthia Stanfield, RBC, Sacramento Valley Vet Tech Association.
John Pasco, UC Davis.
Liz Houston, NBC.
Ryan Allen, International Onshore Warehouse Unit.
Morgan Mechanic, California Advocacy, here with Iowa Review.
High Review, PCA. Larry Review, PCA.
Martha Klein, BCA. Nyla Duncan, BCA.
Mark Virginia, Wall Street.
Patty Rodriguez, Veterinary Medical Board.
Thank you all. Committee chair remark, agenda item number 2. The only comment that I want to make is a reminder of term expirations. In June, one veterinarian's term will expire and one technician's will be up for reappointment. Any committee member comments? Okay. With that, item number 3 is public comment on items not on today's agenda. Hearing none, we'll move to agenda item number 4, review and approval of October 8th, 2019 committee meeting minutes. Committee? Any corrections, comments? Okay, may we have a
Move to
motion?
approve.
Okay, second.
I'm sorry, who moved?
Christie,
Second.
Dr. Warner. It's going to be a short meeting.
Any
Jen?
public comment?
Oh, excuse me, any public comment? Okay. Agenda item.
We have to vote.
Oh, we have to vote. I've never done this before.
Dr. Pollard.
Aye.
Ms. Pulowski.
Aye.
Mr. Ekman. Dr. Lazarchuk.
Aye.
Ms. Laredo. Ms. Shefelt.
Aye.
Dr. Sullivan.
Aye.
Dr. Warner.
Aye.
Dr. Waterhouse.
Yes.
Motion carries.
Okay, moving on to agenda item number 5, discussion and potential recommendation on legislative and regulatory proposals regarding corporate practice of veterinary medicine. I will turn this over to Christy Pulowski and Stuart Ekman, the subcommittee.
Thank you. Okay, so basically you have in front of you the packet. I went back and Stuart and I discussed every meeting that has been had on this topic. I personally reviewed every meeting more than once and listened to all the concerns. We went and kind of reviewed everybody's concerns, and I believe that this packet and what was presented has addressed all of the concerns. The goal is to be solution-oriented and not problem-based. We want to make sure that we're presenting a solution and not continue rehashing the problems. So we have addressed the solutions in front of you, and I believe we have hit upon anything that anybody has brought up, and we have addressed those here. And we can talk about any of the concerns any of the committee might have. It is addressing a practice-wide. It does not address just corporations, so we've removed that stipulation. And it clarifies, even I believe, Dick's concern when he talked about premises and we tried to address that. And we tried to address some of the concerns that were brought up by CVMA. We realize and recognize there is still not language for a non-veterinarian to be an owner, so we do want to address that. And we have addressed Ms. Lute's comments as well. And I think that we hit as much as we possibly could in this packet. So you have 2 copies in your proposal for the regulations in here, and you can see that there's a clean copy so that you can read what is proposed, and then you can see what we have stricken. So I think if you have, and we can go through and we can talk about any questions and start from there, or we can go, I don't think we should rehash. That's my biggest thing. So we can go from there.
I just want to reinforce that in going over all of the public testimony and the discussion from the board from multiple meetings, I think we've had more than adequate opportunity to hear from, excuse me, to hear from people. And I think the document, as Tara has executed on it, is a very balanced and clear document.
Why don't we start with committee comments or questions about, I'd like to take it in order, actually, the memo first, and then we can go to the language. Christie and Stewart identified 18 items. Are there any specific items of that list that people have comments about? I'm going to start then. I would like to ask probably first as a clarification, item number 6. Corporations have prepaid pain management programs. My question, just to be clear, is are you referring to treatment that's done on the patient that isn't recorded in the medical record?
Some of these things are testimony, so some of these things are from what people have said.
Okay.
And I will admit that some of these things are from what Tara has and I had done. Ask your not recorded in medical records, is that
So
what
the
you?
way I read the item point is there's a set menu of pain medication in this case.
Right,
And the individual doctor deems that it isn't adequate, I'm taking to mean, and adds an additional product or a different, say, more expensive product in an effort to not have that show up on the invoice and not charge the client. It just doesn't get recorded in the medical record. Is that accurate?
Yes, that
Yeah.
was the testimony that was
Okay.
provided.
Yeah.
Good, that's what I want to know.
I just want to make sure I understand.
A couple of these, I think I'm going to hold off on questions that I had because I think they'll come up in other committee and public comment. But one more item of clarification, number 12, corporations are setting metrics and benchmarks. And I am presuming that means things like quotas, numbers or kind of tests being ordered.
Yes, it's not just benchmarks, it can be revenue benchmarks, it can be patient benchmarks. So it was a kind of a generalization. And so those are also from the questionnaires and things. So it's just, it's any type of benchmarks that's putting the influence.
Okay. Other committee comments on those items? Stuart? Okay. Would you like to go to the language next?
So we have the proposed language, and based on all of the feedback given throughout all of the meetings, it was, we heard what everybody was saying, and so taking the feedback, we moved to put the language in what is in front of you. And so this is what we have said, and I believe that this addresses the needs.
Dr. Sullivan?
Are we going to go page by page or just blurt out what our
It
concerns are?
probably would be easier if we start with page by page so that we don't start with the block and then go. So we can start with page, I mean, do we want to go with the clean copy or do we want to just stick with
Which is the clean copy, the first one?
the first one? So page 7.
Just a point of order, you may want to ask if there's any comment from the public on the first part that we've already discussed on the first pages.
We could do that now, or incorporate it afterwards.
Okay.
I think I'd like to continue with the language, and then we'll add.
And I have a question. I assume Tara's been over all this? Tara?
Yes, I have.
Okay.
Chrissy?
So, yeah, I think,
Oh, I'm sorry, Dick, you wanted to start?
Later on, I have a comment.
Okay, we'll start
So-
with page 7.
okay, I thought you were going to start on page 7. Okay, so basically when we talk about, well, I think it might be easier to go to, I think I'm going to go to the not clean version because it might be easier because then we just talk about, so let's go to page 12. So when we talk about removing, it just, we started with the type of corporate entity, the names that were on page 12, so everybody's following along, because we're going to talk about the not clean, it's just easier to review. There's not a lot on here. Is everybody clear, page 12? Are we all good with page 12? Does anybody have any questions on page 12 from the committee? Are we good with that? Can we move on? So then, the biggest portion on here would be page 13, section E. Any questions? Yes.
Sorry.
Under the E at the top, this section does not authorize any person, corporation, to furnish any person or animal patient any advice, services, or treatment, or, and I'm kind of skipping parts here, to engage directly or indirectly in the practice of veterinary medicine. So I guess I would like to have an idea of how expansive or narrow that is. Does that mean that corporations can't advertise in general? Can the corporation talk directly to clients?
Right, so the corporation, who is not a professional corporation or a veterinarian licensee, would not be able to discuss matters of animal veterinary health care directly. As far as advertising by the premises owner, which is really what we're talking about when we mention a non-professional, non-licensee. I don't think we've really had that conversation with the board. There's no provision talking about advertising by a non-professional owner. That might be something that we discuss at a later time.
So I think we all are talking about, an individual animal, but does that flow into something bigger than that?
This is, okay, so first off, let me
That's
just
my
say
question.
that this tracks Health and Safety Code, Section 1209, which is a ban on clinic practice of medicine.
Okay.
So this is about clarifying that a non-professional owner, which could be a non-licensed individual or a non-professional corporation, cannot provide veterinary medical services or discuss it, because we're trying to make sure that only licensees and registrants with the board are practicing veterinary medicine. So that is the intent of this provision, and I think that's what it says.
Cheryl, you mentioned specifically advertised. What did you mean?
Well, I was kind of getting, that's my question, I guess, is how expansive or narrow is this? Are we just talking about pricing on an individual animal, or are we talking about something broader as even just advertising?
I think that this is just aimed at the practice of veterinary medicine rather than the advertisement of providing veterinary
Okay.
medical services.
Yeah, I mean, when we're talking about the practice or providing services too.
Okay. Dr. Sullivan?
Yeah, the only problem I have with that is with the word advice. I can visualize that a call center may have or could have a non-veterinarian who takes a call from a client in the middle of the night and gives general advice as to whether that animal should be seen or not. Without diagnosing and treating. Call centers are out there, and I don't think they're manned necessarily by veterinarians or RVTs.
I think that's a good point, and it's up for discussion, really. Do you, as members, believe that advice should be banned as provided by a non-licensee or non-registrant?
The reason I bring it up is that I think it gets over into the telemedicine definition. I think a veterinarian will take calls after hours and give advice to a client without diagnosing and treating, and I think and without doing telemedicine. So I think we have to be careful with where we use a word here and then use it differently in a different section of the code. I'm a little uncomfortable with putting advice in there.
What about if so I think we're about middle of that section. The line begins with patient, any advice, striking advice. So it would say to furnish any person or animal patient any services. What about inserting diagnosis,
Correct.
comma, or treatment?
Yes. Because that's the definition of practicing veterinary medicine.
Related to that, I was going to remark, call centers, the person that you get when you call animal poison control that answers the phone is not a veterinarian. Typically, it's an RVT and sometimes not even a registered RVT or LVT, whatever state it's in. Ultimately, a veterinarian gets involved, but that would be the case too if they called your practice after hours and the person who took the call had questions or concerns would, have a direct line to the veterinarian, hopefully. So consensus is to strike the word advice in that line and substitute diagnosis.
Yeah, I agree.
Okay.
So on the document itself, Tim, diagnosis would follow services. So it would say patient, any services, comma, diagnosis, comma, or treatment.
Okay, moving down.
Okay, so now we're under 4853.6. Then you have 3. Any questions there? Then we can go to the next 4854.1. And that goes to the top of page 14. Okay, so we can go on basically to page 16.
I do have.
Oh, wait, 15. 15, yeah, I did see that. Yes,
So somewhere along the line, I believe this has been discussed previously on the bottom of page 15, but somewhere I missed it because I think this is dangerous language. A number of years ago, I was on the Judicial Council of the AVMA, and at that time, in the directory of the AVMA, they had a list of, 13, 14, 15 different items that you could not advertise in the yellow pages, terms, unless you were boarded or a diplomat. And those were like specialize in dermatology, specialize in cardiology, or put cardiologist or dermatologist in the advertising unless you were boarded or a diplomat. We had a case or a letter come before us that a veterinarian listed her in her advertisement that she specialized in dermatology, and we sent her a letter saying, assistant deceased, or you will be removed from the association. Her husband was an attorney and wrote back to us and said that there is value in being a member of a national association. And if you remove my spouse from this organization, I will seek a judgment. I'll seek a case with the Federal Trade Commission. So we hired a law firm out of Chicago. The office, the AVMA office was in Chicago. And these two attorneys came, and their specialty was association work and FTC laws. And they said, we would love to represent you in this case, and we will do whatever you tell us to. But the bottom line is, and we'll defend all those 14 items, but the bottom line is, you're going to lose. The only thing we can defend are the words diplomat and boarded. And you have to understand that in the FTC rules, that whatever the damages are, it's multiplied by 2.5. So if the suit comes and it's $1 million and you lose, the fine or the penalty is going to be $2.5 million. So, but we'll do whatever you want us to, but we want to tell you that up front. Needless to say, AVMA removed all of those restricted terms. And so I get very concerned when we look at someone who says that they are a veterinary specialist. That's not a protected term as far as I think FTC is concerned. So I got a little nervous when I saw this and just wanted to bring it up. And maybe things have changed in those years, but I'm not sure the term specialist is going to be protected.
Jessica?
So I just want to clarify, the changes on page 15, what we're speaking about now, was not the subcommittees doing, that was the
Correct.
board that approved the language. So this is not really up for debate at this committee, but I think that those comments can be discussed at future board meetings.
Okay, well, I just saw it on here as an
Yeah.
item, so I thought it would be the time to mention it.
I had a related question when I read it, specifically with the term board eligible. I see that fairly commonly, and I just because it's common doesn't mean it's, legal or normal, but What is the committee's opinion of board eligible, for example? Dr. Waterhouse?
I have heard indirectly that the boards, the specialty boards do not allow you to use that term.
Okay. Leah?
I thought also that the language was not board eligible, but services dedicated to, internal medicine or whatever it is versus saying board eligible. So practice limited to something like that.
Yeah, I think that's common, and
Yes.
I
And that'd
also
be
thought
fine.
that was understood as okay. Okay. So on this point then, Jessica, we don't have to address
That's why I
any
skipped it,
changes.
because it
We'll
wasn't something we did. So.
comment.
Not on our agenda.
Okay,
Okay, so the top of page 16. So we're on
Point of
T.
order. When will it be, how can it be addressed?
So it's part of the board's sunset report, and in there, the board had approved specific language to go to through the sunset bill. And so there's going to be multiple opportunities once the bill is introduced to be able to tweak language and ask to work with the legislature to address any concerns.
So it's past the board right now?
The board approved it, yes.
Okay. Must have been sleeping.
I wasn't really ignoring it, but it wasn't anything I did, so I don't know. I can't help you with it. Okay. Exercising controls. We're on the page at top of page 16, so starting with T. Any questions? And really, there is just, under Article 6, there is one line, 4910.1A.
Yeah, and I talked briefly to Tara about this. Just reading it, it gave me the impression that a veterinary corporation could do these things. I think it is redundant. I think there's a section that we talked about that actually says the same thing. And now I can't put my fingers on it, but let me go back to the clean section. I think it was 4853.6, number 3. I think, Tara, wasn't that what we were talking about? Basically says the same thing, so I'm not sure we even need 4910.1.
I think I would actually refer to, on that page 8, at the top of the page, new subdivision E provides that
Oh, yeah.
the statute on premises registration, getting the registration would not authorize any person, corporation, or artificial legal entity other than a licensed practitioner or a veterinary corporation to furnish to any person or animal services, diagnosis, or treatment. So it seems like perhaps we've got it there, and now we have it in 4853.6, so we could consider striking new 4910.1.
any other committee comments? Dr. Waterhouse?
Tara, could you talk about why we're striking the MSO and what's the difference between the previous iteration of this and the one before us, and why we're striking the MSO portion?
I think that the rationale at this point is that it's unclear if it's necessary at this time, because most of the MSO provisions, really, they're the belt and suspenders. If we draw the clear line that a non-professional corporation can no longer unduly influence the practice. The concern was that they would just start changing their practice with these MSO agreements so that they could still influence the practice by having a manager entering into these agreements requiring certain lab tests at certain facilities and requiring certain services to be provided. So since there was a lot of concern about including MSOs right now, and it appears that maybe some other states like Louisiana has scaled back their MSO prohibitions at this time, we should probably just take the baby steps of drawing the clear lines on corporate practice through legislation, and then at a later time, after we have an idea of how well the legislation is working, to prohibit undue influence by non-professional corporations if there's still a problem, because now the MSO agreements are in use and allowing the non-professional corporations to get around the corporate practice ban. The board could return at that time to see if MSO legislation and regulation is appropriate.
Christy Stewart, any other comments before I turn it over to the public? Other committee comments?
Tim, would you mind striking out 4910.1A? Thank you.
Let's turn it over for public comment then, please. And you can cover the language or any of the points in the memo.
Good morning. Valerie Fenstermaker, CVMA. I have collective comments from my row. So on page 13, in the new section, where it refers to in the first sentence, this section does not authorize any person, corporation, or artificial legal entity other than a licensed practitioner of veterinary medicine. Why doesn't that just say licensed veterinarian? What is a licensed practitioner of veterinary medicine? I don't know that we've seen that anywhere else.
Is it consistent with other language elsewhere, maybe?
Perhaps, but we can change it.
Any objections? Sounds.
Okay, and then also often in the code, and I'm never quite clear if it needs to say California licensed veterinarian or if that's understood in all of these areas where you refer to a licensed veterinarian. We kind of like California licensed veterinarian, but if it's understood, we get that too.
Yep, it does say California licensed veterinarian in other areas, so it probably should say California licensed veterinarian. Or veterinarian licensed in California, because it does say that in other areas of.
I think that could be up to the committee. I don't think it's necessary because it's citing the specific statutes that license California veterinarians, but it's up to the committee whether or not you want to put it in there.
Yeah, I only say that because I know it says it throughout the Practice Act. It says, when it references it, it says California, licensed in California. So I don't know if it's just for consistency's sake. I don't care one way or another, so I leave it to the committee, but. Yeah.
I think we should say California licensed to keep it consistent.
I just have a comment, and having reviewed all the other states' Practice Acts, they usually do refer to the state, because when you're dealing with a large corporation that practices in a lot of states, I had to review all of these similar code sections to see whether or not my client could practice in that state as a corporate entity. And it was very confusing in some states because it would say licensed veterinarian, and then it turned out that person could be licensed anywhere. And then there were other states that were very specific that you had to be licensed in California. So, I mean, in whatever state. So I would suggest, just for clarity here, since we're talking about multi-state corporations here, that we clarify everywhere that they should be California licensed or licensed in California. Otherwise, I think you're just going to open yourself up to well, it doesn't say that you have to be licensed in California, and then we have to argue, well, the code section, whatever. I think it'd be clearer if you just put it.
Okay, so the change would be to 4853, Subdivision E, Line 2, striking licensed practitioner of veterinary medicine and inserting California licensed veterinarian. And that change, we would also need to add on page 13, section 4854.1, line 3, of any insert California licensed veterinarian. I think those are the only instances in this, but we could do a search before this goes to the board and insert California licensed veterinarian.
Val?
Okay, and moving down a little lower in that same section, this section does not authorize any person other than a licensed, well, which would now be California licensed veterinarian within the scope of his or her license to engage directly or indirectly in the practice of, and this part, if we're referring to 4826, usually says veterinary medicine, veterinary surgery, veterinary dentistry, and veterinary branches thereof, or could just go to 4826, but it isn't consistent with what we see there.
I'm going to ask you to repeat that.
Well, I don't have my practice act, but I know from memory.
No, not the Practice Act, the change that you
The
referred to.
section, just a few lines down from where we just were, where it starts with this section does not authorize any person.
Okay.
And keep reading toward the end of that, where it says, in the practice of veterinary medicine, surgery, and dentistry is what isn't quite consistent with 4826.
Where you remember it's itemized out, each one.
4826.
So are you requesting to add, at the end of that sentence, dentistry, comma, and the various branches thereof?
Yeah, exactly what it says in.
Okay.
But it does say on 4826, page 8 of the Practice Act, the title of 4826 is Practice of Veterinary Medicine, Surgery, or Dentistry. A person practices veterinary medicine, surgery, and dentistry in the various branches thereof.
Right, the titles are added by the publisher of this LexisNexis version. They're not actually included
Part of the
in,
legislation, okay.
yeah, in the statute itself.
I see, okay. What Val is, an example of what Val's referring to is in the same 4826F, and it itemizes practices of veterinary medicine, veterinary surgery, veterinary dentistry.
Just for consistency.
Okay, so we add that?
A way that's easy for us lawyers, and we have to review this stuff, is that if you refer back to 4826, because that makes it like really clear, and there's no question about, language getting changed while it was being formulated. So it's really helpful if you actually refer back, if you want to use 4826, refer back to that. And just say, as provided in Business and Professions Code, or Code Section 4826.
I thought about doing that, but I don't honestly know where we would put that cross-reference, because we're specifically trying to say engaging directly or indirectly in the practice. But of what? And then we necessarily have to add the list of practice. So it sounds to me like we would just be adding even more terminology after "and the various branches thereof" in accordance with BPC section 4826.
Well, I think that would just clarify it, because then
Okay.
make it crystal clear as to what they couldn't do,
Okay.
or could do. Conversely.
I think it's the only place in the language that has that phrase, so if we just add the adjective veterinary, it's not?
No, it's in the next section.
It's in the next sentence as well.
Yeah.
Where's the next sentence?
So we'll just make a global change for wherever it is, we'll make it match.
So we'll qualify it as veterinary,
Yeah.
surgery, and dentistry. Okay, next.
So then we were wondering down below in 4854.1, where it says a premises registration holder shall not interfere with, control, or otherwise direct the professional judgment of any, and we would put California licensed veterinarian, but the California licensed veterinarian is the supervisor of the RVT, and a veterinary assistant controlled substance permit holder, and a veterinary assistant, and you're referring to their professional judgment. So does a veterinary assistant have professional judgment in this context, or do all of them, because they're all supervised by a veterinarian, then it's the professional judgment of the veterinarian?
That's a very good point.
You can thank Dr. Miller. I'm the spokesperson for the row.
Well, so what about if we add after licensed veterinarian? Or the animal health care tasks rendered by a
I'm just questioning it. I think you need to have some discussion about whether that's really what you meant, or should say, because of the professional judgment of the supervisor is the veterinarian who's making the professional judgment, who has the professional judgment.
I agree. I think that is an important clarifying point, because the veterinarian supervises everyone else. So it's the veterinarian making the professional judgment as to the care, but then it's the other registered or permitted individuals who are providing the care. And the point of adding them here is to make sure that in those employment contracts, RVTs and VAs are not unduly influenced to or compensated on the basis of how much animal healthcare products of the corporation they're pushing. That's the reason why they're included here. So I wouldn't recommend striking those professionals from this list, but I do think that we could clarify it by adding.
Could we carve out after the phrase licensed veterinarian and under the supervision of, and then continue the list of other healthcare providers?
So let me say that again. Any California licensed veterinarian and where does under the supervision of go?
So I think professional judgment of any licensed veterinarian or healthcare provider under the supervision of said veterinarian. Healthcare provider, the list of RVTs and.
So under the supervision of the veterinarian would be inserted in the first line on page 14 after veterinary assistant. So it'd be veterinary assistant under the supervision of the veterinarian.
And we'd have to add an or then
Or.
between licensed veterinarian and registered veterinary technician.
Right.
But aren't you still referring to the professional judgment of the RVT or VASCP licensee?
I missed the
mean, they
first
don't really
part.
have professional judgment. So, I mean, the way it's written, you're still referring to their professional judgment, and they technically don't have professional judgment because they're under the supervision of the vet. So, I mean, I understand what you're trying to do, but I think you need to clarify that you're only talking about control over the professional judgment of the veterinarian. And then if you want to have other language regarding some other kind of control over the other folks.
No matter what you do, it has to be a period after the California licensed veterinarian, because that's
That's what you're trying to do.
Or,
Sorry, you have to have a period after the professional judgment of the licensed veterinarian, because you're talking about the professional judgment, it's a matter of proper sentences and nouns and, so,
Mr. Sullivan?
so that's,
I would say that an RVT has professional judgment.
yes, and we have, yeah, so you could say, it could be professional judgment of the California licensed veterinarian and registered veterinary technician, period. But I think that where we go from there, it has to be a period after that. I don't think that we can continue on.
I think we need to include them somehow.
I'm not saying we don't need to include them. I'm just saying the period in the structure of the sentence needs to stop there. The structure of the sentence needs to stop there. Then we need to, if we want to include them, we have to make a new sentence.
Repeat the whole thing for RVT.
But it can't be about the professional judgment of the controlled substance permit holders and the veterinary assistants.
Right. And I think we could get there by clarifying that it's the professional judgment of the California licensed veterinarian or the provision of animal health care tasks by an RVT, VACSP, or VA under the supervision of the veterinarian. So to clarify that the undue influence by the corporation cannot affect the professional judgment or the provision of animal health care tasks.
How does that ring, Bonnie?
I think that works. Again, I don't want to, as far as the professional judgment of the RVT, I think that's really something that the RVTs and the CVMA needs to determine. So I would say that either you would add the RVTs along with California licensed veterinarians in the first sentence as far as professional judgment, and then the second sentence would deal with the VA-CSP holders and the VAs. And that's really something that you and CVMA need to decide. I mean, I do understand that RVTs have professional judgment. I just don't know if that's, if that's really what but the VA-CSPs and the VAs should not be exerting professional judgment. So there should be two sentences, and
Okay, here's an,
where you attach the RVTs.
well, here's another suggestion. Direct the professional judgment of any California licensed veterinarian or registered veterinary technician or the provision of animal health care tasks by a VACSP or VA under the supervision of the veterinarian. So that way we're getting the veterinarian and the RVT's professional judgment, and separately we're getting the provision of animal health care tasks by the VACSP and VA.
I'll just do it. So, Grant Miller, CVMA. So, the challenge with that, Tara, is that if the contention is that one of the problems is that there are these packages that have to be sold or metrics that have to be met, those types of things are not an animal health care task. Like if you're saying like somebody's a veterinary assistant's working at their front desk and they're selling something, whatever that is, that's not encompassed in the provision of an animal health care task. Sorry. And I don't have a suggestion for a better way of wording, but I don't also want to exclude if you accept the list of 18 things as being problematic, and this is trying to address that, we're now going to miss addressing one of those issues because the provision of animal health care tasks is specific. They're procedures that are being carried out, but this is talking about selling things and pushing certain pain thing. I don't know what it's.
Right, well, it's goods and services. I think we can provide for that. So we're trying to get at the corporation controlling or directing perhaps as the
Dr. Sullivan.
sale.
We are getting into the murky part of things. That has nothing to do with whether it's corporation or a solo practitioner.
I was just going to say we need
The receptionist's
to,
job is to ask the client, do you need other products? And we have these products if you need flea control or whatever. It's a business. Whether they're compensated or not, their job is to sell the products, healthcare products. We call them over-the-counter products when it's up front. But that's their job. And it has nothing to do with corporate influence or not. Unless we're going to say you cannot have any kind of remuneration incentive to your employees. I think most contracts do. So this is where this is the part that it gets really murky. And I'm saying there's no difference between a veterinary corporation, a solo practitioner, or a corporate, a non-veterinary corporation. It's a business, and we're there to provide services and products to our clients. So I might be missing something here, but I think we're getting into an area that we're trying to regulate that I don't think is our purview.
which is why we just want to protect their professional judgment. And I think that that's why we're okay protecting the professional judgment and not, we don't need to worry about anybody who doesn't have that protection, right? If we're just trying to allow somebody to do their job and protect their professional judgment, that's what we need to be worried about. We don't need to be worried about the others because they're being directed by their veterinarian to do their job, like you just said. So we don't, if we go too far, then we're getting in the weeds.
Well, and back to baby steps. Maybe if, once this is implemented by the legislature, we determine that the corporations are unduly exerting control and direction of the sale of the goods, then we can add that as statutory authority later. But does this committee agree that there is a problem that should be resolved and we have some solutions today? And do you want to address goods today, or do you want to tidy this up and move forward with banning undue influence over the provision of veterinary medicine?
Professional, yes.
I would certainly leave the goods part out of it for now. Professional judgment, I think, is a great place to start.
Yeah, I think that's exactly it. I think we need to move forward with the professional judgment part of it.
Before we move on, then, do we have language replacing this line, then?
Well, I think if you end it right at the professional judgment of any California licensed veterinarian or registered veterinary technician, and then you're good. Because it resolves that problem.
No, what about the next?
You period. Cross that out.
So
Then-
we strike veterinary assistant?
Controlled substance permit holder or veterinary assistant, because that's where you can end it.
Dr.
I'd
Waterhouse?
like Tara's opinion. Or should we keep it in as the provision of animal healthcare tests by those two? Tara, what do you think?
If they're not being required to push the goods, the corporate goods, are you aware of, or can you recall any of the witnesses describing undue influence by the corporation over a VACSP or veterinary assistant specific to the animal healthcare tasks rendered? Or was it just pushing the goods?
Oh, there were complaints about the pain meds. I mean, those are being supplied by veterinary assistants and VACSP.
But the decision of those pain meds would be the
Yes,
veterinarian's
it's the
responsibility.
veterinarian. But, well, it is and it isn't.
We did not hear testimony. We got testimony from veterinarians. We never got anything from anybody else. So we cannot speak for anything else. And I cannot say, and I'm not going to get up here and say that we were hearing from anybody else because we did not.
In the example, Dr. Sullivan, that you used a front desk person discussing with the client an over-the-counter versus a prescription item, flea.
I have to correct that because some of the flea products are going to be prescription items that they're going to be recommending.
Okay, that's exactly what I want to propose. Suppose you have three choices, and one of them is the corporate labeled product. And the other two choices cover something different, flea and tick versus flea, or heartworm and flea. And I can see the scenario where often that person at the front desk is selling the product to the client unless there was previous instruction or training about the product's pros and cons, and being required, quote unquote, to sell the corporate product.
And how is that different than a veterinary corporation or a solo practitioner?
Because a solo practitioner isn't going to have Dr. Dick Sullivan's flea and tick preventative on the shelf.
Why not?
Because
If I own 10 practices, I may very well.
Well, then you're the corporation.
Okay, so it's a veterinary corporation. I'm saying it's no different. Here we're carving out non-veterinary corporation for a standard that should be the same as a veterinary corporation or as an individual. We play the same market. So I think if we keep to the influence of the veterinary, of the, what's the wording we have, of the professional opinion, that's where they can't come in and have influence. I don't think that a veterinary corporation should have undue influence on the way that that their business is run either, in the practice. Now, there's a difference here because there's another license you can go after, but what I'm saying is we're strengthening the premises permit so that we have another license or permit to go after if there is undue influence on a non-veterinary corporation. Just the same, and we should be using it exactly the same in all businesses. Because to me, the threat of losing a premises permit is the door closes. And that should be equal across the board. And we should use it that way. We should strengthen that so that we have a vehicle that goes directly to the ownership of that business.
So that brings up a good segue. In the testimony that Dr. Beth Parvin gave at the last meeting, the question regarded, or the example rather, regarded details are fuzzy, but it was an inexperienced veterinarian that was doing an overnight ER and was saddled with a very difficult case. It was a splenectomy. It took a long time. It went badly. And the discipline for an example like that between the veterinarian and the managing licensee who might not have anything to do with it. And I guess I don't see anything in this legislation that addresses that quandary, that potential liability for the MGL that really is kind of out there on an island and not having any direct responsibility over the protocol or the actions of a lot of people, but somebody has to put their name on that. And the corporation comes in, it's not owned by a veterinarian, so they need an MGL that is a veterinarian.
The MGL is not responsible for other veterinarians' negligence or violations of the regulations. It's clear. So, I mean, I don't know what Dr. Parvin was getting at, but I've argued that successfully numerous times. I mean, if the MGL is not, the MGL, that would be ridiculous if the MGL was responsible for every veterinarian's negligence that worked at that facility. That would be just ridiculous, and it doesn't happen, and it clearly is stated in the regulation that they're not responsible for their individual violations. So I don't know what Dr. Marvin was getting at, but that doesn't really happen in real life. That's not a concern.
Val?
No, I think we're good. We would agree.
So to get back to the language itself, I'm wondering if, are you saying that you would want goods and products included in section 4854.1?
No.
Okay, so are you saying that in the first line of 4854.1 that, or a veterinary corporation should come out? Because right now, this would allow a licensed veterinarian or a veterinary corporation to interfere. Because this is prohibiting non-professional
Yeah.
owners and corporations.
There should be no entity or individual that influences the professional judgment of the veterinarian.
Okay, so what we're talking about is in the first line of 4854.1 on page 13, striking after section 4825, strike or a veterinary corporation pursuant to section 4910.
Well, and we got rid of 4910 anyway, so.
If you're going to take that position, then you have to remove a veterinarian license pursuant to 4825, because then you're thrown back to whether
No.
another veterinarian can interfere with another veterinarian's professional judgment. That just gets really.
The veterinarian prohibition is under 4883. So this is, we have to be able to allow a veterinarian to supervise and direct and control the provision of the animal health care tasks. Separately, if they're unduly influencing it in inappropriate ways, under 4883, we're addressing the veterinarian there, which would prohibit exercising control over, interfering with, or attempting to influence the professional judgment of another licensee, registrant, or permit holder through coercion, extortion, inducement, collusion, intimidation, or compensation.
That's not what I'm referring to.
Okay.
What I'm referring to is this first said, that where it says in 4854.1, unless licensed pursuant to section 4825. That means a licensed veterinarian, correct? So what you're actually, if you take out or a veterinary corporation, now what you're saying is that another veterinarian can't interfere with the professional judgment. I mean, you just argued that you wanted to take out veterinary corporation because you don't want to have this apply to them. Now you're leaving the veterinarian, another veterinarian who's licensed, the managing licensee, or any other veterinarian. That just gets really murky. I mean, you don't want to get involved in whether an individual other veterinarian has interfered with the professional judgment of, you see what I'm saying, Dr. Sullivan?
Yes.
Makes sense.
And I said that. I said a licensee or a corporation or any individual or entity should not interfere with the professional judgment of the veterinarian.
You're saying you don't want anybody. It doesn't matter whether you're a corporation or anybody, you don't want anybody, which I thought was, which I read this to be.
This would then, if we start with a premises registration holder, is really, I think, that strengthens the permit, the premises permit law. It says if you are the registration holder, premises registration holder, you cannot interfere, control, or otherwise direct the professional judgment of the licensee. I think that's what we're saying.
Okay, I just want to make sure that if the veterinarian is the premises registration holder,
Right.
that they still have the ability to instruct, inform, and direct the provision of veterinary medicine to other new licensees, to RVTs, to VAs. I mean, this has to be tight enough that licensees can still make sure that the animal patient is receiving the best care. And if that means that the licensee registration holder is interfering with someone else's professional judgment for the betterment of the animal health care, is that going to be a problem?
I think it depends on what your intent is. Again, if your intent is to say that nobody can interfere with the professional judgment of a veterinarian, now that's a little huge in scope. I don't know that you can really do that because, again, you might have young veterinarians, you have people that are training. I mean,
You have a new grad come in and all of a sudden you're saying, nobody can interfere, sorry,
Right.
can't help you.
Right, exactly. So I think you've got to be careful here. And what I thought the concern was, again, and I agree that you also don't want veterinary corporations to overly control the veterinarians, but it's getting murky because veterinary corporations could be 2 people, could be 10 hospitals, could be 100 hospitals. So I think you need to maybe decide what it is you're trying to prevent. When you decide what to add here, unless licensed, which means a California licensed veterinarian or a veterinary corporation, you're saying they can control the professional judgment. If that's what you want to say, then fine. But I think there needs to be a determination of what exactly you're trying to prevent. Because otherwise, you don't really want to be in a situation where a veterinarian, a managing licensee, cannot train new vets.
Well, licensing, however you term it, licensing managers, the way I thought the language was, they may or may not be the premises registration holder. I think you have and if they are, I think they have 2 different hats. As a premises registration holder, I am dealing with the business part of things, and I shouldn't be interfering with the professional judgment of the employees. But then I'm also the managing licensee. I do have control over how the professional part is. Otherwise, because I'm responsible for a lot of any unlicensed activity, the quality of the practice, that's my purview too. So there are 2 different hats that we need to define. So as the premises permit holder, with that hat on, I should not have anything to say with what's going on. And if we can delineate that, I don't even think that we have to because they're 2 different roles. As
But
the managing
they're often the
licensee,
same person.
doesn't
aren't they?
matter. As the managing licensee, I have this responsibility. As the premise permit holder, I have this responsibility. Same person, could be the same person, but they're 2 different responsibilities. I think the definitions are different. They can be the same person. And this is addressing the premises registration holder, period. And that's what we need.
It's
We need-
addressing the premises permit holder as the business manager, not as the person in charge of making sure that somebody's practicing good medical judgment. So like the hat.
I think it's clear. What's that? No, I think this says premises registration holder. It doesn't say anything about managing licensee. Managing license, license manager. We have the abbreviation as the reverse, and we need to clarify that.
I know.
Use one term.
Like
not-
MDC
We'll get
instead
right
of
on that.
MDAC.
Yes, but you still want to remove the or a veterinary corporation. You
Yes.
want to start it with a premises registration holder.
Yes.
Tara?
He wants to strike out the
It's
first
up to
part.
you guys. I've raised a concern just to make sure that when someone says this premises registration holder who just also happens to be a licensed veterinarian, that veterinarian / registration holder is interfering with my professional judgment, that complainant is going to be able to go after the licensee who just is also the registration holder. It doesn't matter what hat they're wearing, as long as their name is on that registration, the premises registration, they are the holder, and this would prohibit them from interfering with.
Well, then it comes back to the complaint. What does the complaint say? If the complaint says that the business part is telling me how I have to operate, then that's the premises permit holder. If the complaint says, this veterinarian is not allowing me to do this kind of surgery because, he wants to do it his way or her way, that's a whole different type of complaint.
Well, but I can see people asserting that leaving out licensed veterinarian and just saying, the premises registration holder is telling me I can't do this surgery. Oh, they're also a licensed veterinarian. Doesn't matter, because as long as the complainant says, the premises registration holder, because I know about this statute, I'm going to get them in trouble. They don't have to say, oh, it's also a licensed veterinarian, or they don't, as long as they're alleging that there's a premises registration holder issue.
Okay, then, you know my intent, then write it clean. They're two different
Bonnie?
situations, and I think we need to clarify it. Otherwise, we're I think, lumping, we're carving out an exception to a licensed veterinarian as a premises holder. And I don't think that's what we want to do if we want to strengthen the premises permit.
We are separately providing for licensed veterinarians. Here, we're saying, if you're a premises registration holder and you don't have a veterinarian license, you cannot exert influence over the medical professionals. Separately, we're saying, if you are a licensed veterinarian, you can't exert undue influence through extortion and blah, 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 because we need to be able to allow veterinarians to interfere with improper professional judgment of other veterinarians for the best animal care.
But we're also then okay that they interfere with how the business is run and have undue influence on how they sell products and sell services. You can't have it both ways.
That's the coercion. We wrote it in here. It's in 4883. Coercion, extortion, inducement, collusion, intimidation, or compensation. Undue influence through compensation. So, if the licensee veterinarian who owns the practice is the premises registration holder, is exerting influence, saying, everybody, you need to be pushing my products, typically that is part of the employment agreement and constitutes influence through compensation, right? I mean, I'm trying to keep this as tight as possible.
Right.
There's only so many words and ways we can limit this. This is our first attempt to try and curb this behavior. I think that you need to differentiate the influence of the licensed veterinarian separately. I think you need to maintain an exemption under the premises registration holder because they may be wearing two hats. And just because they're wearing a premises registration holder hat doesn't mean that their attempt to interfere in the animal's care isn't the best judgment for the animal. They're exerting they're interfering with the professional judgment of someone else who may not be providing the best care for the animal. That should be allowed.
Yes, I agree.
So I think that you should retain unless licensed pursuant to section 4825. You may want to add or the licensee manager.
There's always a problem with statutes when you start off with unless.
When you start off with,
With unless, because people ignore the first section, generally. So I would recommend that you say, a premises registration holder who is not a California licensed veterinarian pursuant to whatever code section, if you want to add the code section, or a veterinary corporation, if you want to still add that language, shall not interfere with, control, or otherwise direct the professional judgment, like we just talked about. Because then that really makes it really clear who you're trying to get at. And so in this case, I'm not really worried about getting a complaint that says this guy who's wearing two hats is interfering with my professional judgment using his premises holder hat. I mean, I can defend that. That's a piece of cake. So that's not my concern. My concern more is what you're trying to get at, which is preventing a premises holder who is not a licensed veterinarian from interfering with the medicine. So just say it that way instead of with the less in the beginning, because people ignore that preface. It's saying the same thing you're saying, but you're just not saying unless. You're saying somebody who is not.
can you propose that again in a sentence?
Just say a premises registration holder,
Other than,
no, who is not a California licensed veterinarian, and you can say pursuant to the section if you want, or a veterinary corporation pursuant to the section, shall not interfere with, control, or otherwise direct the professional judgment of any licensed veterinarian or registered veterinary technician.
Tara?
I'm fine with that, and I think you've mentioned adding veterinary corporation. I think we've already had a discussion about excluding that phrase.
Okay, well, that's up to you. I was just looking at the language. That's not mine.
Okay, so we've discussed a lot. I'm going to read the provision as I understand it to read right now. New section 4854.1 on page 13 would read, a premises registration holder who is not licensed pursuant to section 4825 shall not interfere with, control, or otherwise direct the professional judgment of any licensed veterinarian or registered veterinary technician, period.
So you could add California license, but what happened to the veterinary corporation part?
We discussed removing that because of allowing a veterinary corporation to interfere with the professional judgment of a licensee.
So it's implied, it's looped in. If it's a licensed veterinarian, then it's subsequently a licensed veterinary corporation. So it's implied that that's there.
Necessarily.
Veterinary corporation.
I guess I would argue that the interests of a veterinary corporation are potentially different than the interests of the licensed veterinarian. The corporation is interested probably in making money. So if the corporation is influencing the professional judgment, we don't want that.
Right.
But if this is a licensed veterinarian and there's some other reason why they're interfering with the professional judgment, we would want to maintain that exemption.
So Tim, if you wouldn't mind, on the top of the bottom of that page, the one down where it says veterinarian, strike the comma, add or. Yeah, right there. On the next page. Yep. Up top, where it says veterinarian, comma, registered veterinary technician, strike the comma, put or. and then put a period after registered veterinary technician, and then strike the rest of that sentence. And so that's the language that we're looking at now.
Okay.
So that doesn't, Ken Pulowski from CVMA, Dr. Sullivan, does that address, because it sounded like you wanted everybody on the same playing field for a premises holder,
Okay.
and then this would allow a veterinarian to have the influence, but not a veterinary corporation. A veterinary corporation could be one person, it
Right.
could be the same thing. Now, if they happen to be incorporated, they can't have influence, but if they're not incorporated, they could have influence.
So that is covered in another section where, yeah, go ahead.
Yeah, when Tara was talking about section T at the end,
4883.
Okay, so if the professional corporation is one licensed veterinarian, they would be held to 4883T, which directs that, or prohibits licensed veterinarians, which this veterinary corporation would check because we're talking about one person who's a licensed veterinarian. They could not, they would be prohibited from exerting control in certain circumstances. So we're saying that a licensed veterinarian is not prohibited from interfering with someone's professional judgment until they're using coercion, extortion, inducement, collusion, intimidation, compensation. So we're trying to carve out appropriate instances for licensed veterinarians to interfere with someone else's provision of veterinary medical services to a point.
And I understand that, and I'm sorry it's getting murky, but, my understanding was with Dr. Sullivan is there's a difference between a managing licensee and the premises permit holder. And that any premises permit holder should not have influence, but a managing licensee should. So. Right.
A licensee manager is a licensed veterinarian, so if they are improperly exerting influence under 4883T, they would be subject to discipline.
Right.
Just because they're a licensee manager really has no bearing on whether or not the premises registration holder is prohibited from doing this. The licensee manager is a term used in 4853.6. It's a separate defined term. I don't know how well defined it is, but it is a term in the Practice Act to specify an individual who holds a certain position at the premises.
And I get that. Can you go back to the rewrite? Where's the 4854.1? What did we end up writing?
Page 13. So this will start off with on line 2, capital A, premises registration holder. And then it'll say pursuant to section 4825.
It's covered.
Okay.
So, no, just while we're on T, I just wanted to make a comment, since we're talking about T, 4883T. We had this discussion about professional judgment of RVTs, vet assistants, and VACSPs, so it seems to me like it should be consistent in T. So it should say, influence the professional judgment of another licensee or RVT.
It also says, permit holder, because I don't know when we talked about professional judgment, it says permit holder.
Right, so it probably just for consistency, we might want to be consistent with what we just talked about. Because again, legally, when you get into these discussions, and even with ALJs, it gets very frustrating to try to balance different statutes unless they agree with the language. Because, you know, the Deputy Attorney General will argue one way, and I'll say, well, actually, it means the same thing, and then they'll say, well, why didn't they write the same thing? And so it's just, it sounds like it's like small potatoes, but it would be great if it was consistent here, and it said professional judgment of California licensed veterinarians and RVTs,
Well-
and leave out the permit holder issue.
Well, I don't know. Do we need to leave out VACSPs because they have qualified for a permit issued from the board, and if they're being compensated to handle or,
The issue is professional judgment. They don't have any professional judgment. So that's really my only issue. I'm not commenting on whether you want to include them somehow in this. I'm just commenting on the professional judgment because VAs and VACSPs don't exert professional judgment.
okay, so on page 16, line 2, in subdivision T, it begins judgment of another. We would strike licensee, registrant, or permit holder and insert California licensed veterinarian or registered veterinary technician, period. Through, and then we continue with the rest of the sentence, leaving out permit holders.
I like it.
I think I have. Oh, well, did we already correct on 14? We already corrected, the board may require, we didn't. So then, when you, back to 4854.1, the employment contracts, so again, that section should be consistent with the section we just corrected, because, you know, if the intent is to prevent the professional, interference with the professional judgment, you shouldn't be able to get the employment contracts with the VAs or the VACSPs who don't exert professional judgment. Again, it's your call as to whether you want to have a separate section on them, but they don't exert professional judgment. I think we need to be consistent.
I propose we take a 10-minute break, and the first thing we do when we come back is we read the revised language. 11:30, 11:40, let's reconvene. I said I never get to use it. Yeah, at least. What I'd like to do is, first thing, review this language. I'm going to make sure Tara gets back here before we. Oh, good. Review this language that we've changed before we move on to anything else. And second, I want to acknowledge the next public commentator who has brought some practitioners here to answer questions that we want to have an opportunity to interact with. So I will,
Okay,
and the
so
language.
do you want me to wait on my other comments?
I do.
Okay.
Thank you.
That's fine.
So the two lines are going to be the 4854.1 and 4883T as in Tom. So let's start with 4854.1, please. Page 13, the bottom. Would you mind reading it? Because I don't want to do this.
Okay, so for 4854.1, it now says a premises registration holder who is not licensed pursuant to section 4825 shall not interfere with, control, or otherwise direct the professional judgment of any licensed veterinarian or registered veterinary technician. That's the main change.
Perfect. And then page 14, excuse me, page 16 at the top. I think that was just a language change, actually. California
Yeah.
licensed DVM or RVT, we modified licensee with.
Right,
But
and
did we not change the
we-
registrar?
we struck
Yeah, let's read
permit
that too,
holder.
please.
Exercising control over, interfering with, or attempting to influence the professional judgment of another licensed veterinarian or registered veterinary technician through coercion, extortion, inducement, collusion, intimidation, or compensation.
And insert California before the word licensee, I think.
Yeah, we'll have a global change to add California.
Or licensed, I guess. Yeah, perfect, okay. Dr. Waterhouse.
I'd like to discuss the word compensation in that last line. Because as a practice owner, I compensate all my employees.
Okay, so we have to read that with influencing the professional judgment of another through compensation. So are you paying them in order to interfere with their professional judgment, which means compensating them for recommending to clients certain drugs or services, which the treating veterinarian may or may not believe in their professional judgment is appropriate for the animal.
To Dr. Waterhouse's point, if the word compensation wasn't in there, could you affect the same result with coercion, extortion, inducement?
Yeah, I think the concern comes in because a lot, veterinarians are paid on
Production.
So I think that it becomes a concern because I think it would be hard to separate out, and it would be very difficult to say that they're not paid. And I get that it's professional judgment, but they're paid on production. So to say that it's compensation, to add compensation in there is very difficult to add it in
I'm
there.
not clear. Are you saying to keep it or lose it?
To have it in there is difficult to read. It should not be in there.
If I can make a comment too, this is Mark Cushing with the Animal Policy Group. The other words, coercion, extortion, inducement, collusion, intimidation, are essentially felonies, and then you throw in compensation. The point is, that's a category of behavior that no one's going to defend, and no one's going to object to trying to restrain anybody from exerting that type of control. You throw in compensation, and I don't know a practice in the country that doesn't have some version, as Chrissy just said, of 20% or 19% production. And lawyers do it, engineers do it, Cleveland Clinic does it. Surgeons that do 40 surgeries a week get paid more than surgeons that do 30 surgeries a week. Does the compensation system motivate certain heart surgeons to do more? Probably does. Is that illegal? Absolutely not. And so you will have more debate. There'll be more lawyers on behalf of veterinarians back in front of, well, not you, but in front of the CVMB, trying to decide how broad that scope is. And I understand you're one example, counsel, but I think you're better off just taking that word out because it just doesn't belong. It's like listing 5 species of animals and then throwing in a car. I mean, it's just not the same thing, and the behavior is too broad. Whether it's an individual, whether it's a veterinary corporation, whether it's any other type of corporation.
You would agree then, if there was undue influence for whatever act or non-act, those other words, coercion, extortion, inducement, collusion, they would cover it.
I wouldn't be excited to take that case of defending a client who tried to coerce, extort, induce, or collude or intimidate somebody in their medical judgment. I think that you can agree on. So I think taking it out, as you suggest.
Well, I think if it happens, it doesn't matter whether it's through compensation or any other means, right? If we have it in there, it's specific. If we leave it out, it doesn't matter by what means.
But what I'm hearing is if we leave it out, we've relieved ourselves from a lot of other potential problems, and taking it out with all of the other concepts.
Right, that's what I'm saying. If you leave it out, it's not just about compensation, then it's
Right.
about other things. You have it about coercion, extortion, inducement, collusion, and intimidation. Doesn't matter in what way.
Including compensation.
Exactly.
And you don't have to say the word compensation
Right.
to.
It's specific,
get
it's
the
not
money.
being specific. It's about every other, it can be about anything.
Tara?
My only comment, it's your determination as to what include. My only comment is just, if you believe that the animal, patient, and the public are better protected by prohibiting influence over professional judgment through compensation, I would leave it in. If the public and animals are better protected, to make sure that someone else isn't determining the professional judgment over the treatment of the animal because the treating veterinarian is going to make more money if they recommend lab tests that most likely otherwise would not be necessary.
So that's a good example. Overtreatment, let's call it, just as a category. If overtreatment is occurring, the client, the public isn't going to know that often. If we didn't have the word compensation in this section T, could we still address that with all of these other words?
I don't believe you could.
Well, overtreatment happens in corporations and in non-corporations. So I guess what I'm hearing is we don't have any means to address that at the moment. So the downside of adding compensation is
The downside is that you call into question virtually every compensation agreement with practicing veterinarians in the country, let alone just in California. A production-based compensation system puts an economic value on the productivity of a veterinarian. It is not hard to argue then that each hour of the day, each half hour, each 10 minutes, it could be a consideration. How am I doing? Am I moving fast enough? Lawyers feel that pressure. Engineers do. Doctors do. Now veterinary medicine is going to single itself out in California and say, you can't have a compensation system that recognizes productivity. And the other thing it does, it implies, it's somewhat, frankly, this is a problem with theoretical legislation. This implies that there's veterinarians today in this state that are suspending their medical judgment. They're thinking it's not in the best interest of the animal, but I'm going to make an extra $50 a day, and I'm going to prescribe something, do something, because I have that possibility. And I just think that's...
You're saying that doesn't happen?
I can't say it doesn't happen, but I think to the extent it's risen to the point that you create this hornet's nest for yourselves, I think council is going to be busy full-time advising on how you define what you meant by it. Just to throw the word compensation in and say that's one of the tools, particularly aligned with that other, what I call the 5 horribles, which are essentially felonies. And so it's, if I'm a veterinarian in Fresno and I read this, I go, oh, I got to apparently take production bonuses or production out of my compensation system.
Hold that thought. Christie and Stewart, of the 500, let's just call them, complaints, were there not a substantial number that involved overtreatment? Or the requirement to do something that the veterinarian didn't feel was necessary?
Well, I would say it's more about them wanting to, and I don't have my results with me, but it's more about not necessarily going along with what they would normally do, or, and there were definitely revenue-based, having production-based. So that is a concern. It's definitely a concern on the veterinarian's part. So having to meet their target for their production.
Stuart?
I think if you leave the word compensation in there, it allows for the revenue-based compensation as long as there's no undue influence as to which products, and as long as they're not being influenced to push specific products that may not be appropriate. So I think you can keep it and allow that kind of compensation, and keeping it provides a codified section where if they're stepping over that limit, the code can address it.
Mark?
We all use the example of interfere with and attempt to influence. The phrase begins exercising control over, so you are in jeopardy if you exercise control over a veterinarian through compensation. I don't know a single practice
Over the
owner that's not
professional
attempting to exert some control over their younger practitioners
But
through compensation.
But that phrase is exercise control over the undue influence, or in this case, the way it's written, the influence of the professional judgment, not
Right.
of the compensation.
Exercise
by
control over the
compensation.
professional judgment, correct. Professional judgment is a behavior, it's a professional work. It's not their sideline. You're trying to, you are in fact trying to incentivize your practitioners to be productive. And this would be the only profession I'm aware of that would now say you can't do that. You're exercising control over the professional judgment through compensation. That's in effect proscribed, it's prohibited by this language. It's not just attempting to influence or interfere with. And that phrase, I think, opens that door. I don't think it's your intent. I'm not assigning that intent to any of you, nor to council, but I think that's how you could read that. And I think, and I appreciate, Christie's comments there. I think to some people, they don't want to be in that system. Thank God we have 1% unemployment for veterinarians. If you don't want to be in that system, and you don't want to work for a practitioner who has a production-based system, go work somewhere else. And you can find a practitioner that won't, but I think it's a privilege of a practitioner to have that. That's a reason why 80% or so have signed up for it.
Bonnie, exercising control over the professional judgment through, should compensation be in that?
Okay, I have two comments. First of all, I agree with Christie that compensation is just a means rather than an end. That's the way I would put what you had said, was that compensation is assumed. I mean, compensation would be one way, firing would be another way. I mean, so you could compensate somebody, you could be exercising undue influence by compensating, you could exercise undue influence by firing, you could exercise undue influence by giving them bad hours, like making them work, all the night shifts or something. There's several ways you could go about punishing somebody that you wanted to punish because, you wanted to exercise control over their professional judgment. So I think compensation is just another means, and I agree with Mark that putting compensation in there opens this up to disgruntled veterinarians and RVTs to go after their bosses because they're saying that there's undue influence because of the compensation, which is a common practice. So I think compensation should be removed because it's actually the means rather than the thing you're trying to prevent.
And so if compensation is removed from this phrase...
Is your microphone on?
Excuse me. If compensation is removed from this, and the other change we made was add California licensed DVM or RVT, period. Well, not period, but we took out the red permit holder. Would coercion, extortion, intimidation, inducement, collusion, would that cover what is intended to prevent?
I'll give you an example of how it would. I think the answer is yes, it would. If I'm the practice owner and I take a young practitioner and I say, here's the deal. I'm going to pay you an extra $150 per spay or neuter if you can do it in 15 minutes. I'm going to clock you, okay? That's how it's going to work. That's an inducement. I'm like, wow, I could use it. Great, thanks, I'll start doing that. Yes, that affects your professional judgment. Now you're at the 8th, 9th, 10th minute. You're where you are in the procedure, and the clock's ticking, and you've got an inducement hanging over your head or out in front of you like a piece of candy. Okay, that would cover that. This would allow that person to say time out. This is improper under what would be the revised version of this, without the word compensation in there.
Or you could argue that that person who sees the 12th minute and recognizes they aren't going to get it done utilizes his or her professional judgment and says, you know what, I'm not going to make $150 today.
Right.
I have some problems.
And that could be no harm, no foul. You wouldn't think well of the practice owner, but nothing bad happened. But the
Correct.
thing is, if you knew that he attempted or she attempted to do that with a younger employee, you'd have a basis to I think, revoke under that, for in the same, you could revoke, and I think that'd be appropriate.
I don't know about that. Bonnie?
Actually, sorry, but I have a problem with several of these words. And the problem is, again, they're not legally defined. And, I know what you're trying to do, and I totally understand, and I don't want to frustrate the process here, but, I've been accused in my whole professional career. I was a microbiologist for 20 years. I was a business owner for 20 years. I've been a lawyer for 20 years. Of intimidating everybody. So, I don't swear at them, I don't yell at them, I don't throw things at them, but almost every employee that I've lost has said I was intimidating. So I have a real problem with that word, because it's a style thing. It's a personal way that people act, and I know a lot of people in this room could be called intimidating. So, I have a problem with that. That's just kind of too wishy-washy, and how do you prove that somebody's intimidating? Coercion is also sort of the same thing. I think you could maybe have some factual basis for coercion, but I do have a problem with the intimidation word, because I think that could be misused and end up with a lot of litigation and stuff that the board doesn't want to have to deal with just because of personality differences between veterinarians.
I have a few other, if I could, comments.
Sure,
And we
go
do
ahead.
have 3 VCA doctors that aware of what some anonymous folks said in the last hearing, would like to share with you and basically answer any questions you have about their practice and whether those, some of those 18 items occur. On page 12, under the definitions, or under 4853, you've inserted the names of, and now you want to, presumably a corporation, to name all officers, partners, directors, shareholders, and members. You pretty much told a company that's a public corporation, which VCA was for a number of years, that they couldn't comply, they couldn't be a for them to try to list all the public shareholders at any given time. I'm not sure what you're gaining by that. And that, I think you could just leave the language as is. Right now, it's basically one shareholder and then the others, as I reread the statute, but I don't know that you need to include the names of all those. I think it's, if you want it to be a barrier, if you want it to dissuade companies, because they may have private members of a board that don't want their name used that way, you could have that effect. I don't know why you'd want to do that and what the goal would be for protecting the public. So I'd raise that issue for you to think about. On the next section.
Hold that thought. Let's talk about that. What adds, how does it add our, how does it add our enforcement ability if we have the names of all the officers and all of the shareholders?
That helps us determine whether or not the individuals are complying with the professional corporation statutes, or if it's a general corporation and the statutory requirements to be reviewed.
Is there a better way to do that than that? I mean, I did not know that was your intent. I mean, I actually just couldn't read that and reach that conclusion. So if that's the intent, it seems to me there might be a way to do that that's not as onerous, because you could probably determine compliance short of having every name of every shareholder. And in the example of a public corporation, that's a seriously onerous task. And in California, has done well by, public corporations. By public, I mean, Wall Street or NASDAQ.
I'm pretty sure I modeled this off of the pharmacy law.
But wouldn't it be
So-
covered under 4910? I mean, would a California corporation be able to get a veterinary corporation, become a veterinary corporation without already having provided that information pursuant to 4910?
The problem is that under 4910, you're a professional corporation, you file documents with the Secretary of State, and then they rubber stamp it, not really checking anything.
Okay, so
But
they don't
the
check it.
Veterinary Medical Board, having no documentation at all, is supposed to enforce Moscone Knox. So it would be helpful if this board had authority to collect this information to make sure that the professional corporation is following the law. And so, and to determine whether or not someone who's claiming to be a professional corporation is not a general corporation.
You may think about, you might consider, counsel, if you want to have some carve out for a publicly traded corporation, where just the ability at any given moment in time to go through the system and determine who are all the shareholders of record of a NASDAQ or New York Stock Exchange company. And again, I use that example because, VCA for many years was publicly traded. That I don't know what you gain by trying to have literally all shareholders of a publicly held corporation identified. I just throw that out. I think that's the one hiccup I see here. Otherwise, I don't want to spend your time on it.
It also seems a little onerous. A corporation is going to be a dynamic process too. In the course of a calendar year, the shareholders are going to change. So, I don't know, corporations, go ahead.
So just to clarify too, the language that's in black underlined, that was previously approved by the board to address in our sunset, to address the issue with MGLs and who the owner of the premises is. And so this language that the board has already approved. And it is modeled off of pharmacy law. And it goes to the board's ability to deny the holder of the premises registration. And I know for pharmacy, they also fingerprint specific individuals that may be a shareholder. And so if you have some convictions of people who are owning the business and they're applying for the premise registration, we would be able to deny based on convictions.
But that applies to the black, not the blue. The blue is new today.
Right, so the,
So you could, I'm
so
not
the blue,
objecting to the other.
yeah, so you're just objecting to adding the names
Yeah.
of?
No, the type of corporate entity, comma, the names of, but particularly the names of. Yeah, I just
Okay, 'cause
delete the names of. Yeah. And leave it the way the board had it. I don't think that needed to be improved. Just my own view, but.
Okay, let's discuss that. If we didn't have the names of, would that,
I think that we would still, on the application, if you play that out, we're going to want their names. Because you're not just going to list shareholders, what are you going to list if you're not listing their names?
Dr. Waterhouse?
How many shareholders own VCA? How many shareholders are there? 1,000, 5,000?
Currently? I said
Shareholders.
Currently,
Okay.
VCA does not have thousands. It is owned by a single entity, and I don't know the name of the entity.
Okay,
that
but the
merged.
shareholders,
Yeah, the shareholders were, when it was
Okay.
publicly traded, there were thousands and thousands, and they could be foreign. I mean, it wouldn't be limited necessarily to Americans. It could be mutual funds from
right.
Germany, Belgium. I don't think it matters. It's that example I'm thinking of, and I don't think you want to make it harder for a publicly traded company. I just don't know what you gain.
So that's the point he's trying, is for these publicly traded companies, there can be thousands
Yeah.
of shareholders.
and they could change by the month.
Yes.
They change
Daily.
by hour, truly. And they don't exert control over.
It's just if we're going to do it, have an insert for publicly traded companies, not for everybody else, but for publicly traded companies, not having to list the names.
I think that'd be an improvement.
Yeah, and I would agree, because I represent a large pet store, and I don't really know how many shareholders they have, to tell you the truth, but that could be a problem.
Believe it or not, I have only one more comment to make. I think you all have made amazing
Well,
progress.
hold the phone. Let me just see if we can, or are we, go ahead.
I would prefer to have a little bit more time to research this issue, so perhaps I could do that over the lunch period, and we could
Okay.
return to this conversation.
You lose weight coming to these meetings.
Yes, I do.
I
All right.
apologize,
Next-
counsel,
next-
for
next item.
being the source of your lack of nutrition. The only other comment, Dr. Sullivan made a suggestion that you adopted on the next, the top of page 13, under sub E, where you deleted advice and you inserted diagnosis. I would suggest, for the purpose of avoiding, I think, a lot of potential confusion and a lot of persistent questioning as to what was meant, why not use the way it's defined and delete services and say diagnosis or treatment? Essentially, that's what's defined as the work of a veterinarian. When you include services, almost like advice, you open a wide veterinary practices, again, regardless of ownership. Veterinary practices provide a range of services, all of which do not constitute veterinary medicine, but it can be a gray area. And I'll give you an example from one of the corporate clients within the Mars organization, Banfield. They publish now what is widely appreciated nationally, the Banfield State of Pet Health Report. That is chock full of information that they hope pet owners and veterinarians read. This year, once again, it's about obesity, which has been an issue that they've talked about a lot. There's a lot of services provided, and no one's trying to discourage veterinarians from doing that. I realize the qualifier, which is used, within the scope of veterinary licensure, but it gets you into this definitional area about when does something going on in a clinic or above a clinic that's related to the clinic fall under licensure, or is it a separate service? And I would just take the word service out. I think the statute defines veterinary medicine in virtually all states as diagnosis and treatment. The telemedicine, prohibition talks about that. I think that's a better form of language, and I would just suggest you consider, in the spirit of taking out advice, as you already have, delete services and insert treatment.
Okay, let's,
Or diagnosis or treatment.
go ahead.
Well, we do a lot of services, so you might want to put in there professional services.
Yeah, I thought the same.
Okay?
Okay, if we put in professional services,
Yeah, that would help.
that would help, but would that obviate the concern?
No, I think if it's professional service, it's defined by the license of the professional, and that makes sense. But that to me limits it, and you need some limiting factor, otherwise folks are going to say, what can't we do? And you don't want people confused, and I think they otherwise would be.
Okay. Bonnie?
Could you just put veterinary services instead of professional services? Because I think veterinary services is defined someplace else.
If that's a defined term, then is that in the?
Yeah, I think so. I can't
How's that
off the
ring
top
for
of my
everybody?
head tell you where, but I believe it's defined.
Okay, let's make the first thing after lunch a consensus on adding veterinary services to that line in 4853E, and then let's break 12:10 and come back at 1:15, please. Thanks. Tim, may we go to 4853E, where we left off? We proposed to add the word veterinary to services. Is that how we have it? Okay, everybody take a peek. Is that what we all agree on? Public veterinary services, we happy? Okay. Tara, you want to?
Okay, to resolve concern about disclosing information that would be onerous to compile for corporations, but to allow the board to make sure that the veterinary corporation article is properly complied with. I have created 2 separate subdivisions with respect to the premises registration application. So if you look at subsection or subdivision C, I've taken out in the highlighted language, if applicable, maintained the type of corporate entity, and then moved if applicable after that, and then stricken the names of all officers, partners, directors, shareholders, or members from that provision. Subdivision C begins to lay out what the premises registration application must contain, the information in the application. So in new subdivision D, I'm providing for veterinary corporations and what they will need to include in their premises registration application. This is based on the limitations under Moscone-Knox for filing as a professional corporation. In this subdivision, it would require the owner or operator of a veterinary corporation to include in their premises registration application the names and titles of each officer, director, shareholder, or employees. All of those entities listed are specifically listed under Moscone-Knox. And then also requiring that any changes to the officers, directors, or shareholders shall be reported to the board within 30 days. I'm omitting employees because the employees of the veterinary corporation could change on a pretty regular basis, so that in and of itself would be onerous to require the veterinary corporation to report changes in employees to the board. Under new subdivision E, this would provide for any other corporate entity and what they would have to report in their premises registration application, which would read as follows: if the owner or operator is a corporation other than a veterinary corporation as provided under subdivision D, the application shall set forth the names and titles of all owners, corporate officers, general partners, if any, and the agent for service of process. This list reflects the information required to be reported to the Board of Pharmacy for registration of a pharmacy. This would also include the requirement to report to the board any changes in the owners, corporate officers, general partners, or agent for service of process within 30 days. This seems like a sufficiently transparent provision while attempting to limit the amount of information that would have to be compiled by other corporate entities such as shareholders. That would not be included for all of the other corporations, but would be maintained for veterinary corporations. That's what I've got.
Dr. Sullivan.
Do we have any situation where the owner is not a veterinarian and is not a corporation?
Yes.
Yes, absolutely.
Is C take care of that?
Yes.
Okay.
C is for everybody, and then D is only if you're a veterinary corporation, you have to report additional information on top of what's required in subdivision C. And if you're an other corporate entity under E, you would be required to also provide that information.
I guess I would also question the need for listing employees under the corporate I mean, I know you quoted it comes from another board, but,
No, this comes from the Moscone Knox
oh, okay, all right.
requirements.
Committee comments?
I had the same question about the employees. That was my only question, or employees. But if it's already,
So under Moscone Knox in Corporations Code Section 13401, Subdivision D, it defines what a licensed person is. And that licensed person includes a person licensed under the provisions of the Business and Professions Code to render the same professional services as are or will be rendered by the professional corporation of which he or she is or intends to become an officer, director, shareholder, or employee. I mean, you could contemplate striking employees, because arguably an employee would not have any controlling interest in the veterinary corporation. I'm just trying to maintain the board's ability to ascertain whether or not the entity that is claiming to be a professional veterinary corporation is in fact complying with Moscone Knox.
So in that use of the word employee, does that mean licensed employee or all employees? Sounds like it's licensed employees.
Yeah, it would have to be licensed employees because they would be licensed to render the professional services as provided under the Veterinary Medicine Practice Act.
I'm not sure that's clear in our language.
If you want to keep employees, we could clarify it by or licensed, registered, or permitted employees.
Licensed, registered, or
Permitted.
Licensed professionals. What do you mean they're not all
they're not,
licensed?
it's because they're a permit holder, doesn't mean they're licensed. It's a permit, it's not a license.
Yeah, that wouldn't cut it. Comment, Bonnie?
Yeah, I would just think that employees would be really onerous, and I don't see what it gets you, really, additional information that would be helpful. So either eliminate it or clarify it would be my recommendation. Because listing all employees, that's arguably kennel attendants and janitors and secretaries and.
Right, so either we clarify it that it's only the employees who are licensed, registered, or permitted by the board, or we strike the requirement to list all employees.
What is the purpose of your wanting the list of employees in this context?
To ascertain whether or not the entity that's claiming to be a veterinary corporation is in fact in compliance with Moscone Knox. And Moscone Knox then defines what a licensed person is, officer, director, shareholder, or employee. I think that in terms of, we're trying to get more transparency in the premises owners and operators. So I'm not exactly, I can't tell you off the top of my head exactly what employees provides the board. Arguably, the board would have information, hopefully, maybe not, on the employees practicing at any particular location. A lot of registrants and permit holders may or may not list their business address as their address of record, so they're not going to know who per se is working as an employee at the veterinary corporation. But if you don't think it's necessary for this purpose, which I don't really have a strong argument to include it because part of the registration process is about making sure that the individuals involved in a veterinary premises are operating lawfully. So to the extent the board would require fingerprinting of a premises registration applicant, licensed employees presumably have already been through that process and we know who they are. So we don't necessarily need to include employees in this provision.
I mean, that would just, I would just think it would be onerous, and if it doesn't really get you any additional information that you need, I think it's something that lawyers would argue. I mean, it might cause you more trouble than it's worth, unless it's something you really think you need.
I've included it because it was under Moscone Knox and for discussion.
Yeah, no, that's what I understand, but from a practical perspective.
Yeah, I have to agree that I think it's a lot of information, and knowing how often employees change in the veterinary field and the turnover rate, I have a feeling that it's a lot of information that may not be necessary for the board to have to handle. I mean, that's a lot for staff to have to handle. So that's what I would be concerned about, is a lot of information that I don't know that it gets us anywhere. That's what I'd be concerned about.
Okay, so can we contemplate in Subdivision D, line 3, after director, comma, add or, OR, and after shareholder, strike or employees.
Happy? Okay. I think the language sounds good to committee. May I ask for public comment? Okay. Are we at a point we can entertain a motion?
No, because I have. Yeah.
Sorry. I would like to go back to and revisit the compensation word.
Okay.
Because I heard everybody's comments and I listened to what people say. So I expressed concern over the.
Just for, I'm sorry, for reference.
Okay, yes.
We're
So
on
we
page
can.
16.
Yes, go back
T,
to page 16.
T of 4883.
And I expressed why I had concern, because we do, in the veterinary world, use compensation. Many veterinarians are paid on thank you, Grant. Production-based compensation. So I expressed concern over that, and it's hard when you read this and you look at it and you use words and then you use compensation. But I also express concern that many of the complaints that we heard from veterinarians was based upon their compensation being used as part of the influence that was used over them. So I don't want us to ignore this. And I think that we in the way that this is reading, and I want us to look at this closely, that this is not about that production-based compensation. This is about the professional judgment being influenced, and it's being influenced to whether they are holding it over them in their compensation, or they are being told that their compensation be withheld because we had somebody that their compensation was withheld, or in some other manner. That is the influence that's being done, and they're using their professional judgment. So I think we need to discuss that, so I don't know that I want it removed. I don't know that we should. I think we need to look at that, and I think we need to discuss that.
Tara?
I had an idea to clarify compensation. So, because it's only certain types of compensation that we're concerned about. It's not necessarily practice compensation. It's compensation for certain services being provided to the animal patient. So I was wondering if I had an idea to add after compensation for unnecessary or improper veterinary services. That way, we're kind of clarifying what compensation we're talking about. It's the unnecessary or otherwise improper services provided to the animal patient. Thoughts?
It sounds good. Unnecessary seems rather open to interpretation. And I think dependent on whose intimidating point of view one has or not.
Well, how about someone who's not intimidating? So just as not nice a guy as
Go
you
ahead.
could ask for it. I think that this is a good time for MDC and the board ultimately to consider it's in protection of the consuming public. This is not a labor board. This is not a board that's meant to protect associates, new practitioners. It's a board to protect the public. Absent what I understand to be the case, absent any meaningful evidence from pet owners in California that they believe they're being abused or overcharged or in some fashion mistreated by licensed veterinarians due to practices of the sort we can all speculate about, I don't think to wade into defining the type of services for which you can have some aspect of your employment agreement or understanding reflect or not is good policymaking.
I'm sorry to interrupt, but you're going to go on and you're going to give an example, and I'm going to lose the thought, so forgive me. But you're right, this is intended to protect the consumers, but the consumers, there's no such thing as a consumer board of protection for consumers and they can't know what they don't know.
Well, let's go to
So
human
how do
medicine.
they know they're overcharged if it isn't brought to their attention?
Let's take the field of health professions, which is probably most rampant with this type of issue, which would be human medicine, where to practice defensive medicine in anticipation or fear of a malpractice case, defense lawyers lay out for doctors, okay, here's your checklist of everything you better do to protect yourself from the claim. It's fair for a client, a patient, to say, wait a second, I now understand that you had me run through 5 tests, and I've got an expert telling me that those 5 tests, frankly, were unnecessary. And there's civil remedies, and you don't need to go to a state agency board to get protection there. And I think to set this up, because the example you gave, Christy, which I appreciate because you laid it out, was mainly from vet professionals complaining.
That's a good example, except the difference between veterinary and human medicine is, for example, the entity of insurance companies in the human world, which of course we have, but we're not at that level yet. And I'm sure there will be some pushback eventually. This test was unnecessary by Trupanion or whoever, for example. But at the moment, we're not there.
So you're now, but you're tiptoeing, I think, diving in, maybe more than tiptoeing, into waters where this board, or you're going to recommend to the board, rather, that you basically arbitrate and decide the content and scope of employment agreements in private veterinary practices. And I would just, that is a decision that I would pause and want to get a considerable input on whether that's really where we want to go here. Because to even with your example, Council, to define necessary and define unnecessary and in whose mind and who decides that. And I think you created, again, without a problem, really being at your doorstep, a solution that's pretty expensive and going to be onerous. We've used onerous a lot today, and I'll hand this off to Bonnie, but I think that's the road we head down pretty quickly with that.
I mean, I think that to take what Christy said first and then what she said after lunch and to combine them both, maybe you stop at intimidation, assuming you leave intimidation in there, but I mean, assuming that you leave intimidation, and then you say through any, and you could use the word unlawful or think of some good word, Tara, some good word for this, through any something means such as undue compensation, and add some other things. I mean, add some examples, things of what you're really talking about, or to use the legal term I would use, to include but not limited to. So through means such as compensation, through means to include but not be limited to undue compensation, or something to that effect, where you mention the compensation, but there's also other things, because at this point, you're using compensation, but there could be other things that people do, like, if you're not going to cooperate with me, I'm going to only have you work 1 day a week and cut all your hours, whatever else they could do. So if you had some language that said, through any, and I don't like the word unlawful because that's just not a good word, through any means to include but not be limited to compensation, and if you wanted to add other ways that pressure could be put unlawfully on the professional judgment.
Lawful is, it's a great word because it's more black and white. It defines what is and isn't. Ethical is too unwieldy. And for example, let's say a practitioner who works in San Diego starts doing, I was going to give the example of tests for Lyme disease, but it just occurred to me it's not a good example because the standard test in the field is a tabletop in-house snap test that has 4 items on it, and Lyme disease is typically or can be one of them. But if you do a test that the reasonable and prudent veterinarian would conclude is unnecessary, for lack of a better word, there must be some means to address that. Dr. Waterhouse and then Sullivan.
So to your point, that I actually like the language that Tara mentioned, so compensation for unnecessary and improper veterinary services. So yes, there's a big gray area there, but there's a whole gray area in practice. That's our whole complaint process is based on gray areas, but we send it to our in-house consultant, we send it to expert witnesses, and they sort that out. And so I think this would go through that same process. So, they're used to dealing in the gray areas. So that's my point.
Can I ask you, Doctor, if you permit, in your case then, just if you were the veterinarian, I gather you're going to be entering into your medical record, frankly, a fairly self-serving, I'm not picking you out, but it'd be a fairly self-serving paragraph, probably handed to you by a lawyer, that tells you every time you recommend something, make sure you put that in there, so you've made the finding that it's reasonable and necessary under current, modern, whatever veterinary best practices, so it's there, and you've covered yourself. And if that's the way this goes, and I'd probably tell you to do that if I was your counsel, how would we advance the public interest in doing that? I mean, I just think I'm wondering what problem we're trying to solve here really for the public.
Sorry, you've just then, with that phrasing, you've just made a statement that it is appropriate. And the medical consultant, the veterinary medical consultant or the expert witness says, no, it isn't. So there's always, 3 stories, yours, mine, and the truth.
Ooh, that's bad.
Well, the real truth. I mean, there's always a truth because all of our stories are point of view. So you know what I mean.
Traditionally in disciplinary cases, we're faced, and it's easier to determine what undertreatment is. That's more black and white. When it comes to overtreatment, I've gotten into this discussion a number of times with I guess you'd call a colleague, and that person could justify everything that they were doing medically as good medicine. And in my opinion, it was overtreatment. So undertreatment's easy to look at and decide. Overtreatment is more of a personal opinion, and I think would be very difficult to, a judge who has never practiced in their life would have to make that decision. And
But how about to Dr. Waterhouse's, I think, excellent point, that treatment, that point of view against a veterinary medical board consultant or an expert witness?
Two expert witnesses, and then a judge decides.
Keep in mind, though, they're not the ultimate decision makers, so that's the board's role. So the ALJ will say their proposed decision, and if the board feels that the case wasn't made or that this was not unnecessary, that you feel like the case has been made in the reverse, then you reject the decision. But it's not an ALJ who has the ultimate decision in these cases.
So if you are working for, I'll take a solo practitioner or a corporation or something in the middle, and your employment agreement has, subsection Z, you will receive X percentage, or you will receive a bonus of, or some amount of compensation for something. Maybe it is a wellness plan if you're a Banfield doctor, because there's a belief by Banfield that it's a good idea. In other words, you get some percentage. On its face, have you just walked into this? And have you created what would be an actionable item against that veterinarian because the company dared to put in a compensation agreement
No.
a reward?
And you said yourself, lawyers.
Don't quote me against me, that's not fair.
You said lawyers and engineers are compensated similarly, and I completely understand and agree. So I don't think that's unreasonable. Bonnie?
That wouldn't be.
I would just say one thing as far as the legal, the way it works with the ALJ. I mean, I know that this board, or the board, is struggling with, how many cases they want to send over to the Attorney General and the costs and all of that. So I would add that little part of this, because if your analysis here is, well, it will all come out in the wash, once it were to go to an ALJ, and if the ALJ goes either way, either goes with the higher treatment was better or the lower treatment was better, and then, yes, it's true that the proposed decision would come back to you, but look at all the money that the board has just spent going through that process. And I mean, that's my problem with something like unnecessary medical care, is that really is so up to interpretation, and it's not going to be it's not going to be simply interpreted, because it will be something that my client will fight and the ALJ will fight, and we'll go to the hearing and we'll do a 4-day hearing to decide, what's necessary, and then it'll come back to you guys and it'll be more time and money. So
Yeah,
it
it's
seems
not-
to me like it would be better to try to clarify it.
It's not just a good point about the money that the VMB would spend, but the money and time and pain that the respondent would spend. The pet owner is out of the loop by this point. Say nothing about the pet. Let's see.
I'm going still with this, if you want the compensation in there, to say something like after intimidation, assuming you leave that, through any means to include but not be limited to financial compensation, limitation on hours, or something about hours, just give a broad sense of what kind of thing you're looking at, which is more likely then to be something that the enforcement team can look at, rather than having to send it to the DAG and have somebody hire me and have us go to the ALJ to decide whether the treatment was more than necessary. So, by saying to include but not be limited to, you're allowing compensation to be one of the factors you look at, but you're also looking at a limitation on hours or excess hours, whatever. And by saying include but not limited to, that just gives you open-ended stuff to look at as far as factual things to look at. So that gives you the ability, as the enforcement team, to look at those issues.
Mr. Cushings, what do you think about that?
I would, with the greatest of respect for the intimidation of this council, I'm not intimidated to disagree with her on this point. I think I would put the word back in you don't like, I would say, or unlawful compensation methods, period. At least you've got a standard, to your point, Chair. By putting unlawful in, you put a standard out there that you can't utilize it. Great, have everybody hire a lawyer and figure out what's lawful or unlawful, but it is at least a standard, and you're basically telling people don't break the law.
But ours is not strictly a law. It's a standard of care, and it's a floating boat, right?
There's no definition for unlawful.
Yeah.
Like, that would be a very hard thing for the enforcement team to have to decide, and it would be a personal, somebody would think this is unlawful, somebody would think that's unlawful. By allowing yourself to look at the compensation, then the enforcement team can look at it, and they can compare other compensations, and they can say, well, this was really outrageous. I mean, this person wasn't just given compensation for work, this person was given like way extra money for using these particular drugs. And it would be a thing they could decide in the House.
Bonnie, wouldn't you agree, though? If you're going to do this, I think you'd want to have counsel and perhaps with others that want to help, issue an advisory opinion that declares what is not deemed to be unlawful or is not deemed to be undue,
About
which would
what?
include.
About
production
advisory
bonus.
opinion about what?
Defining what is okay, because if I read that language,
That's a long book.
but if I read that language, if I'm a lawyer and I read that language, it's like, well, what's okay and what isn't? And I don't think, Bonnie, your solution gives any guidance as to what you can put in a compensation agreement. If we're talking about a one-off situation, that's one thing. If we're talking about what do you put in an employment agreement, that you're going to face it every time you hire somebody. What can I put in there that pertains to compensation, other than here's what you get paid per month?
We're not talking about an employment
Okay,
agreement.
Jessica.
So Bonnie, I don't think you're intimidating. I think, Mr. Cushings, I think you're very crafty. When it comes to compensation, I do appreciate your suggestion, and from someone who's overseeing the enforcement team, I would like the committee to seriously consider what Bonnie is requesting.
I like what Bonnie has suggested, and I say we put that language in.
So let's talk about what that sounds like. I don't know if I have, well, I'll start. Exercising,
He's got it up there.
oh, good. Do you have what he has up there?
You don't need any means, but.
It should be through any means, including, but not limited
Yeah.
to. Then that gives the enforcement team the ability to look at other factors.
And then,
And I have no problem with that, I mean, from a defense perspective, because we can look at the factors as well.
Should any means including but not limited to actually be inserted in the a line above it before coercion? So veterinary technician through any means including but not limited to coercion, extortion, inducement. I'm still struggling with compensation. I hate the word unlawful, because unless, what does that mean? They were guilty in a criminal case? What is that? Do we have to define that it's unlawful? How do we do that? I mean, you're absolutely right when you mention board staff. They have to try to read this stuff, advise, and determine whether or not to submit something for disciplinary action. So I keep coming back to needing to define what compensation is, or limiting the scope of what would be a violation of the subdivision.
I think you have to do that, just as you suggest, because if you're asked this question, and I may be the one that writes the letter on behalf of our practices and asks you the question, does this now, using council's language, does this now include, number one, production bonus, number two, compensation for wellness plan adoption, number three, and go down the list of all the different ways you incentivize a doctor to produce more and then make more money. And I should be entitled to an answer respectfully from this board to each of those questions. No, it doesn't include production bonus, which I've heard Chrissy say. I'm not trying to punish that. No, it doesn't include promoting a product. That's okay. Wellness is a good idea. I'm just saying you're in that thicket now, and this language doesn't get you out of it. It just kicks the can down to somebody else to say, what do you mean by what's a fair term that's not objectionable and what's not?
On the other
First of all,
hand,
the language isn't what we proposed. The language that's up there is not. The way we turned it around to change things. So the idea was that you don't want them to exert control by coercion, extortion, inducement, collusion, intimidation through any means, including but not limited to.
Oh, gotcha.
Compensation. So I think that takes it out of this issue
Right.
because, again, your first thing you're looking at is coercion, extortion, inducement, collusion, intimidation. You're looking at that first. Was that present? And was that done through, how was that done? So was it done through compensation? Then that allows the enforcement team to be able to look at, this person's compensated this way, this person's compensated this way. Look at this. This person received like 10 times as much as this guy received, but he was made to sell whatever. Do
So
whatever.
it's a subset.
So it's the including but not limited to that gives them the ability to look at other factors, but it doesn't just tie it in with quote compensation. It's coercion by compensation.
How about if we modified compensation by a word like penalty?
Incentivized compensation. That, if you put,
Either, I'm not sure if limited to penalizing compensation or compensation penalties.
Well, it wouldn't be
They might-
just penalties, it would be like also the other way. It would be either lowering your hours or, you don't want people to coerce people to do stuff by threat of, we'll pay you more, we'll pay you less, we'll give you less hours.
couldn't you just say by incentivized or,
Incentivized, I like that.
yeah, well, yeah. Since it's incentivized or penalized compensation, you got both, I think.
Bonnie's qualification would work. I would withdraw my objection. If the compensation is a form of coercion, extortion, inducement, collusion, intimidation, I repeat, most of which are felonies, if it's part of that plan, great. It's relevant. It's not a separate item. I think that.
That's what I'm trying
If that's
to-
how you mean it, then I would withdraw my concerns.
I agree with Bonnie's language. I think it gets us there without having to qualify compensation.
How about the committee? How does that read? Okay.
Okay.
So how, is that how it reads then?
Yeah.
I have a hard time seeing in
No,
the
it
yellow.
doesn't.
I'll read it.
Take out the or through.
Okay, you go to intimidation, my favorite word, and then you say through,
Yeah.
through any means to include but not be limited to compensation.
You delete or before through, though.
Yeah.
Yeah, that's good.
So it reads, exercising control over, interfering with, or attempting to influence the professional judgment of another veterinarian or registered veterinary technician through coercion, extortion, inducement, collusion, intimidation, through any means, including but not limited to compensation.
Right. I would have no objection.
Okay, sounds like a winner.
That's a high fair bar.
Okay, good, moving on. Where are we moving on to?
If three attorneys
I can just
agree,
say
I
one
think
more
we're
thing and
there.
then-
Something's wrong, huh?
I know that you want to allow him to have his veterinarian speak, but I just had one thing that I
Okay.
brought up and then we broke, and then. I
That's
think
right,
that-
I apologize.
Okay, and then I'm done, I think. On page 14, it was the second part of 4854.1, and we had corrected the first sentence to eliminate the professional judgment of VAs and VACSPs, and I also think we need to take vet assistant, controlled substance permit holder, or vet assistant out of the second sentence, because I don't think the board is entitled to get the employment contracts with people who aren't included in the potential exercise of professional judgment.
I thought we did.
Well, no, we did it in the first part. Did we do it in the second part?
Yeah.
Oh, okay.
Yeah, it's gone.
All right, John, thank you.
All right, good. Do you want to,
Yeah, all I'd like to do is just introduce three Northern California VCA veterinarians that are all medical directors with varying levels of experience with the practice. Not to respond to the anonymous comments made in October, but to give you introduce you to their backgrounds and take any questions you all have about them on any of these issues that they're now very familiar with, having sat through today's meeting so far. So I'll let them introduce themselves. I'm not going to question them. The questions are for you to ask. Great. And thank you for allowing us to do that.
Martha, you want to start?
Sure.
Put you on the spot.
Hi, I'm Dr. Martha Klein. I'm the medical director of VCA Mueller Prep Medical Center. I graduated in 2008, and since then I've had a variety of different variety of experiences in different practices. So I've gone from completing 2 different internships with corporate and non-corporate hospitals, and then working in private practices and corporate-owned practices, from 1 and 2 doctor DVMs to all the way up to referral medicine. Over the past years, I actually came on to VCA Mueller by choice. I left the company for about 2 years to work in a private emergency practice, and elected to come on to VCA again because I do believe in their practices and how I wanted to practice as a veterinarian.
I'm sorry, before you go on, it's going to help me. It's going to help me keep you straight. The current VCA that you're at, that you're medical director of, what was the name?
VCA Mueller Pet Medical Center.
Mueller, and how big is it? How many?
It's now a 14 doctor practice. It's a 24-hour both emergency and GP practice.
Great, thanks.
I'm Larry Correa, VCA Ashers up in Redding, California. It's depends on the time of the year, but 10 doctor practice. We were up till this last year 24 hours, but having trouble staffing it, so we're kind of a hybrid practice. 24 hours, 4 days a week, and no doctor 3 days, or overnight 3 days a week. But I've been at the practice for 34 years prior to VCA, and then they bought us in, I believe, 1990 or 91, and I think we were their 18th practice, and I've worked there ever since.
Wow. You went to veterinary school at 12.
Yeah.
Okay, thanks.
Hi, I'm Tyler Yu. I'm the medical director at VCA Sacramento Animal Medical Group. I have been in this position for the past little over a year. I graduated from UC Davis in 2014. I've worked at one other practice. It was a VCA in Pittsburgh, Pennsylvania, and that's VCA SAMG.
Do you have any?
Thank you guys for being here. I really do appreciate it. And I know you've probably heard all of the things that we've gone through. So what kind of experiences have you had? And we would like to hear both experiences because no practice is perfect, but we like to hear the good. And, obviously, because there's good. And to be honest, we've heard good experiences about VCA. So we don't want there to be any misconceptions about that. So what kind of experiences can you share relating to what we've talked about and what we've resolved here? So what issues and concerns do you have with some of these things?
I'll let you lead the way on that one.
Boy, there's a lot. I know one thing that has been great for me personally is that we had an old kind of rundown building when I first was practicing there, and then after we got bought out by VCA, then they realized too that our practice was needed a lot of help, a lot of infusion of cash, and a new building, and so they helped up the entity as far as new not only a new building but new equipment, new surgery stuff for me, plating equipment, and all the stuff that goes with that. So they increased our level of medicine and care tremendously, and it helped with that. Things that I couldn't finance myself initially, and they've partnered with me and have been a great partner throughout. I've not I've known the original owners for 30 years, and I didn't know who they were when they first came in the building. I actually thought I was buying the practice, and then this gentleman come in and they're counting bottles, and I think, hey, that's working because that was the plan. And then they say, we're your new boss. Of course, I was intimidated because like, who are you guys? And how's that going to work? But they've been great in my instance as far as everything they told me they would do. They have done. They've been it's nice to have an HR department and attorneys and the equipment we need and the CE that they provide, and so I can't say that they've ever we're quite a ways away being up in Redding from corporate headquarters in LA. They don't, I wouldn't say bother us, but they don't, they kind of let us do our thing, And of course, they check in, but it's not, I've never had the, intimidation where, you need to do this, you need to do that. I'm well aware of the numbers because as far as, gross coming in, but that's just good business practices, and I keep an eye on that, personally. And so, but I've never had them say, hey, you need to get chopping, so. Anyway.
You wanna go, Mika? So I have a lot to say on a lot of topics. I'll try to keep it short. It seems like a lot of the question comes in or has been about our Care Club package and not anybody really saying much that it's really related to the Care Club that VCA.
Just for the record, could you just summarize what a Care Club package is?
Yeah, absolutely. So VCA has a package.
Can you speak closer to the microphone,
I'm so
please?
sorry. I thought my voice was loud enough. VCA has packages that are called Care Club packages. And from my understanding, that was some of the deliberation of were these problems, and did through these packages, was it inappropriate medical care that these packages were quote unquote pushed for or provided for these clients. And initially I wasn't so thrilled that they came on scene because they actually saved the clients more money. Finances are a little bit dicey with veterinarians to begin with. So what's great about these packages is that these packages are developed for different life stages for the pets. So you have kind of these kitten, puppy packages, you have these kind of middle-age packages, and you have these geriatric or senior packages. And they all include different things. So if you have an already spayed and neuter pet that's with a kitten age kind of below a year, they include vaccines, they include unlimited visits. And it includes those things for the clients. Then there's one that includes spays and neuters. In addition to all of that, microchipping, fecal tests. The next stage is going to be kind of your middle to older dogs, where they have your ability to do annual blood work, where that's the time frame that we really want to start catching these early developments of diseases. And then we have these senior packages where animals that have severe dental disease or have chronic problems that you can take radiographs, and you can offer these to clients. What I have found is that I've actually had clients, it's not a product that we push, so to speak, but it's basically a payment option that we can offer these clients. There's not a lot of payment agreements in veterinary medicine aside from these packages. If you go to any hospital, they're not going to have a payment option for a client. You have care credit, or you have some other entity that works outside of that individual clinic. What's nice that VCA has started to offer is that these are packages that have inclusions. They're not telling practitioners that you can't do additional things or that you have to do all of those things included. It gives you the option of these are the things that this package will pay for. If you need to give additional medication or if you need to offer the client additional lab work for follow-up, it's not included in the package, but it doesn't prevent you from making those recommendations. So what I have found with my clients is that they're actually able to offer better medicine and treat their patients or their pets because it breaks up that cost. Some of these things that we're asking to do for that 10-year-old dachshund is like almost a $1,600 procedure for full mouth extractions and x-rays. And what we have found is that through these packages, we can break up that cost. And these clients are so thankful to have the opportunity that they can actually treat and take care of their pets. So I just want to be very clear about that. It doesn't limit what a practitioner can do. It gives us more options.
And on top of that, I think one of the issues before was that there are radiographs included in some of these packages, as Martha was or Dr. Klein was saying. And on the flip side to that is that I would never recommend those radiographs.
Can you speak closer to the mic for the webcast,
recommend
please?
those radiographs, sorry about that. Recommend the radiographs if it was against my medical recommendation. If it was a old dog with CHF, it would never be like, we have to take these radiographs because it's part of the care club. Rather, it's more of an option and it does help, especially with the payments, and also it's like they pay 85 cents on the dollar. There's a discount inherently with those things that are offered in the package.
Thank you for offering that information and explaining it. I appreciate it. Does anybody else have any?
Maybe I just didn't understand what you just said about the example of a CHF dog that didn't have radiographs as part of its package?
No, I'm sorry, but let me be clear in that I think that one of the concerns that we had talked about before from your guys' last hearing was that because of this Care Club package, some of them, they do include radiographs, but that we were doing them unnecessarily. Is that a correct statement?
I wouldn't say, I wouldn't use the word "we" globally, because you're not the only corporation. And honestly, I'm not even sure which that was an example of, so don't take it personally.
No, so I guess then we should take a step back and be clear about our experiences with VCA and how that can apply to the concerns that were raised the last time. And if you guys say, bring certain things up, then maybe we can address it more clearly and definitively. Maybe that may be more appropriate.
Yeah, so on that example, that's a good segue. The example was actually given by one of the Veterinary Medical Board consultants. So that's an in-house veterinarian, one of 3 people who, all of the number of complaints that come into the board, one of those 3 people has eyes on. And this person, Dr. Parvin, has been doing this for, I don't know how long, but a long time. And she used as an example a 5-year-old Jack Russell Terrier that got as his package a 5-view radiograph on an annual basis for his checkup. Well, to our earlier discussion about overtreatment, most people would attribute that to the overtreatment category. So if you had a patient, I'm understanding you to say that had the symptoms of CHF and they happen to be in one of these Care Club packages that didn't include radiographs, I presume you're going to say, hey, we got to take radiographs.
Sure.
And they're going to say, hey, okay, and yes, we're going to pay for them. So I don't think that's our concern at all. That's just good medical judgment. But I don't think, honestly, you should take, any of you, globally, all of those concerns that were raised at the last meeting with the callers and the survey responders as specific to, VCA proper, for example. But there clearly are examples, many of them, and I'm not privy to those 500 surveys. I learned about it at the April meeting for the first time, and then the callers, like everybody else here. Other committee members, Dr. Waterhouse.
So just tell me if I'm correct, that it's my impression that, like, within VCA, there are different practice models. Not every VCA hospital practices exactly in the same way. Is that correct?
Yeah, I would say that we're kind of, each practice is definitely different. Practice across town from us is they see more, they're more of a wellness kind of clinic. We're more kind of emergency walk-in clinic. So they're all, each clinic kind of has their own culture. They have the same, basis for what, standard of care and things. But as far as, we all kind of morph into what our culture is.
Do you think, I wouldn't expect you to have a specific example, but put yourself in your client's shoes and the people who, not new clients necessarily, but the people that come regularly. Like most practices, my impression is people come to see Dr. X. And if Dr. X isn't available and they are constrained to see Dr. Y, they must find that acceptable or they wouldn't keep coming to the practice. There are more, I think, multi-doctor VCAs than there are, other entities. So would you say in your years of VCA, clients have a perception of a difference in, however you want to qualify it, level of practice, outcome, between VCA versus anywhere else? Do you ever have a client that comes in and says, gosh, I'm not going to go to them because they're not a VCA, or vice versa?
You're looking at me.
Yeah.
I think there's two different scenarios kind of related to that. I mean, not all of us we're not veterinarians before, so we have experience of being clients as well to veterinarians. What I've seen is with working with some veterinary practices that are not VCA versus practices that are VCA, is that on the professional level, I can offer clients almost I don't want to say guaranteed, but a very close to guarantee a certain standard through VCA hospitals. I think clients when you see a change in the ownership of the hospital, that's where it gets to be a little bit interesting from what people view as the single owner versus now it's corporate. I think that there's just an aversion to corporation buying out a hospital that's very unrational from the clients, some of them. Because you do have a kind of a generational gap where a lot of those, I've been coming here for 30 years and Doc used to do it this way. And now VCA's just ruined everything. And then you look back and you look at these clients who are kind of those complainers. And yeah, they've been coming there for 30 years, but they come every 5 years. And they don't see the transition in medicine. So you have almost these unwarranted complaints where people, just because it's corporate, think it's bad. Those have a tendency to be of a different generation than people who see the validity in the corporation and what they can actually provide. I have seen, I actually take care of a client now who has gone through a corporation just because they believed in that standard of practice through the corporation. And it not just VCA, they actually were going through a different corporation and elected to come to our hospital because it was another veterinary corporation. Because they believe that as they traveled across the United States, if they kept with that same corporation, their standard of care would be at least some sort of guarantee that the corporation kind of supports. Does that answer your question?
Thank you. That's perfect. That's exactly what I was referring to. And I'd also add, the concerns are not just regarding VCA. You just happen to be the volunteers who came up to the table. Clearly, you're a big player, but again, don't take it personally. Christy?
Yeah, that's actually what I was going to allude to. So you have a good situation and you're fortunate. So our goal is to provide protections for those veterinarians who aren't in such fortunate situations and don't have the same protections and are in situations where they are influenced in their practice of veterinary medicine. So I would ask you, in that the language that we spoke about today, would you want that protection if you were in a situation where you were not in the situation you are today, you were being influenced and being told you had to do things, would you want this language for you and yourself to have that same protection?
Yeah, I know it, when I first came out of school, and I would say my mentor or my first boss, I was young and dumb, and he helped me a great deal, kind of coaxing me through and telling me, oh, this is how we do it here and whatever. And so is that him, and of course I used whatever product was on the shelf, and this is way back, but get a cat abscess, and we all used azithromycin, which was, what pen strep and some dexamethasone or something, and that was 35 years ago was kind of the thing you did. You wouldn't do it now, but that's what was on the shelf, and that's so. If we look back at it, I said, gee, I wish I would have had something different or used something different, but that's what he bought, and that's what's whatever heartworm medication was on the shelf, that's what we used, and that's what we pushed, and so is that coercing me to do something that I don't know, but I hope your standard of care just continues. The other thing is that I think every veterinary practice goal, not only to help animals, is hopefully to make a profit. So it's not the evil corporation that's going out and, all that we want is profit. That's hopefully the goal, or at least an output of every single practice, or they'd go out of business. And no sense in working as hard as we do as a profession and starving to death. We just went through the car fire up there. We personally donated $40,000 from our clinic to take care of the animals. The campfire, the Australia, they sent, I don't know, $100,000 to them. So definitely more than just profit.
Christie's question, I think, is excellent, and I want to drill down on that a bit. Take yourselves back to however many years, 2 years, 5 years, before you were the managing medical director, rather. Could you live with this language?
I will touch on that if that's okay. I was nervous a little bit as we were started these proceedings, but seeing how everybody has kind of worked through the verbiage, I'm still a little concerned about the term compensation. But overall, I do think you narrowed down pretty clearly of what this is to include and how it's supposed to protect. It did seem like it was very broad, and it was a little bit unnerving for just as a practitioner in general. But as it is and what has come to the major conclusion, I personally am very comfortable with the verbiage that is used to kind of narrow down the scope of what is being discussed. I do think some of it is protective, and having worked for not just, other corporations that are not as large as VCA, haven't fortunately had experience with dealing with substandard medicine or the support of substandard medicine. So I can see where these proceedings would kind of limit the risk of that. So I do agree with it. Again, I'm a little concerned about the terms of compensation just because that's how we make our money, and that is very vague. Every doctor is compensated to some extent. I'm going to use kind of VCA as an example because that's where a lot of these programs are set up, just because it is a large corporation. They have the finances, they have the HR department to do this, they have the marketing department to do these things, whereas your smaller corporations are not going to really have these packages, so to speak. But a lot of it is, we do get based on, we do get production based, and through promoting these packages, I can't say that we're making more on it because we promote it, but it gives the opportunity to offer things for clients that may not otherwise be available to them. If you don't promote it, people aren't cognizant of it, then you're kind of doing a client disservice in the fair market where they're not able to make a choice by not giving the option to either choose that product or that package versus to kind of the a la carte. They can still make that decision. It doesn't mean that you have to, I'm not going to treat your pet or else you choose this product. So it's a little bit, that's a little bit concerning. I think that how you ended the verbiage with clarifying compensation is more palatable, but that did concern me personally as a practitioner.
Committee comments? Questions? Any more comments you want to offer? I also want to echo Christie's thanks for your coming forward. It's helpful, and to hear it from the horse's mouth is really sometimes important.
Thank you.
Thank you.
What do we got here? 2:20. Okay. So may I ask, Jessica, do you think we're at a point we can have a motion to vote on this language?
Yeah, I think we went through it, unless that's really the committee
I
decision.
move that we put this through, please.
So what's the motion? Honestly, I didn't hear you.
Can I move that we pass this language through to the board for approval?
As amended during the meeting?
I'm sorry, as amended throughout the day.
I'll second that.
May I second
I
that?
think Kevin beat you to it. He just wasn't, he wasn't in
Stuart
the
seconds.
microphone.
I
It's
think
like both of
Dr.
them.
Lazarev beat him to it.
Dr. Lazarev, second.
Okay.
Committee comments? Public comments? Vote.
Right. Dr. Pollard,
Aye.
Ms. Pulaski.
Aye.
Mr. Ekman,
Aye.
Dr. Lazarev,
Aye.
Ms. Shefelt,
Aye.
Dr. Sullivan,
Aye.
Dr. Warner,
Aye.
Dr. Waterhouse.
Aye.
Motion carries.
Yay. This goes to the board.
Yes.
Just a recommendation.
Okay, we okay pushing on?
Thank you, Mr. Chair. I'm not saying you'll never see me again, but appreciate your.
We'll see you at the next meeting.
Okay, that brings us to agenda item 6. Update from Complaint Process Audit Subcommittee, potential recommendations to the full board. In recent conversation with Jessica and others, we have talked about the work this subcommittee has done over the last 4.5 years. Prior to Dr. Lazarev joining in August of 2018, Dr. Grant and I reviewed a number of cases, as did we the one time we got together. That last time was actually about a year ago, and it, I think, was determined, and I'll let Jessica weigh in to give more detail, but that we've kind of eked out the benefits of the audit review that we have done. Additionally, the subcommittees collaborated on expert witness training with the enforcement team, contributed to a model expert witness opinion that currently serves as a template for expert witness training. And so if the goals of the subcommittee were to improve the quality of expert witness reports and ensure expert witness training that really wasn't there to the level that it is now, and additionally introduce feedback from expert witnesses, I think as a subcommittee, it has done its requirement. I want to have committee input, but I'd like to start with Drs. Waterhouse and Sullivan, because they were on the Veterinary Medical Board in July of 2015 when the committee, when the subcommittee was formed, and ask your thoughts about continuing or not.
I think the work is the offshoot of the work was recommendations for the expert witness training and program. But the original impetus was having board members, and it originally started with board members, and then it came to the MDC, to review cases and just have another focus on cases and how they process, and both from a learning standpoint and an oversight standpoint. It wasn't about expert witness training. It started as looking at cases, and I mean, that's our responsibility, is oversight of board function. And I would be disappointed if that was discontinued.
Dr. Waterhouse?
I agree with Dr. Sullivan. I think that, especially in the beginning stages, I think it met a real need, and that I think that it should continue in some form. So I would try and figure out exactly what the needs are now and try and make it so it's apropos now.
Dr. Lazarev, let me ask you, you've been involved for a year.
I mean, I think there was some good work there, and, you know, the board's kind of changed its complaint process, and, you know, maybe that needs to be looked at to make sure that, you know, things are still being, I don't want to say settled, but yeah, settled, you know, in an appropriate manner. Does it need, you know, 2 meetings a year to overlook that? I don't know. You know, now that they've changed it a little bit to where the board, before it issues something to the DA saying we would settle for this, is that going to, help the complainant or hurt them in any way? That would be something to look at and try and monitor. But there would need to be a few cases available to review, and I think that'll be down the road a ways. I certainly don't need to have the PTSD of looking at those cases twice a year, because they do stick with you there. They are long, drawn-out processes, but maybe less frequently take a look at them.
Jessica, you're on the spot.
So when looking at the overall concern about enforcement and the concerns, specific concerns that this board has raised over the years, which I've watched the board meetings and the history of this committee, I understand a lot of the concerns centered around subject matter experts and what was put into an accusation, and then what ultimately ended up in a proposed decision, which the board was really concerned about. I think that there were also a lot of concerns about the actual process itself. And so I think that, and you guys can correct me if I'm wrong, but this was put in place to help address that. When I came in, what I found, though, is that this committee was reviewing disciplinary cases that have gone through the entire process, which could have been 3 or 5 years later, and then reviewing them and then creating a list of concerns. Most of them, correct me if I'm wrong, had to deal with what the subject matter experts were opining on, what ended up into the accusation, then ended up in the judge's decision, and then it got to closed session. And by this whole time, we have spent a lot of time and money into it, and ultimately, the board disagreed with what was in there. And then that information, though, wasn't used in a way to go back to provide that input to the subject matter experts. And it wasn't really being utilized. Oftentimes, by the time the committee was reviewing the cases, we weren't using those experts anymore. And it's not, but to me, by the time you're looking at a case that's 5 years after we took discipline, is too late. I think a lot of the problems that we're experiencing in enforcement starts early on. It starts with the internal process. It starts with what kind of case we're transmitting to the AG's office, how well organized it is, what we put on the transmittal. It also it goes back to the subject matter experts, what they're looking for, what they're trained, what we're telling them to identify. I experience a lot of frustration with subject matter experts who have, I get a case and it's an accusation for me to review, and there are some violations that are incorrectly cited because the expert had misinterpreted the law, or there's clear violations that aren't in the accusation because the subject matter expert didn't include it. And when I go back to the staff or to the DAG and I say, well, what about these violations? And the DAG says, well, it wasn't in the expert opinion. And so to me, that's a huge disservice to the consumers. That's a huge disservice to the board. It's extremely expensive. And all of these problems, I think, start from the beginning and not the end. And that's where we need to focus our time and look at our processes and change what the subject matter experts are looking at. I want our subject matter experts to opine on whether or not the standard of care was followed in certain circumstances, not on specific legal interpretations of the law, because they're not attorneys. And that's where I think this focus, if you want to keep this committee, I'm okay with that if we're focusing on what's truly the underlying problem. And I feel like what it was done before was looking at the problem way late in the game where we're not making any input. So.
Go ahead.
How where would you have us in that process to review these cases? I mean,
So I think your work with the revamping the subject matter expert program is very helpful. I think that to keep you guys in on the process, so you can come and evaluate how we are now streamlining the process with receiving documents and uploading documents electronically, to look at that. And then potentially look at some, if we can do some redacted versions of subject matter expert reports, so you can see whether or not the true problems are being addressed. But I want to bring you guys in early on while still protecting the confidentiality of the specific cases. That's where I would want to focus you guys on.
Let me ask Jessica if you think, and this may be difficult to answer because you're just 2 years into this, but
A year and a half.
a year and a half. Oh, seems longer.
Tell me about it.
I guess I'm interested in, you make a very good point. The cases that Dr. Grant and I started reviewing almost 5 years ago were old, and they're 5 years older now, so they didn't have any value in and of themselves. And you're also correct. Almost to a person, I'll bet you there were maybe 3, and I'm just guessing, but a small number of individuals whose reports we read that were expert witnesses at the time that remain expert witnesses. And so my impression was a big goal of the process was to read these cases with the purpose of improving the expert witness report writing. Cheryl?
Sorry. So my understanding is to look at the whole process, not just the expert witness, but the whole process.
Which we did, we certainly
Yeah.
did. And Dr. Lazarchev alluded to the, I won't use your adjective, but it can be, some of these cases were really dramatic events for lots of individuals involved. And not all of them are like that. But the other thing is, the whole process to look at, recall, the subcommittee only looked at the cases that were chosen by Anne Marie and Candace. They brought them in. I don't know what the process was. We talked initially about a percentage, a selection of, but I don't know how that was adhered to. We did get a list, and we went through that list, and then each continued visit, of which there were about a dozen, as you'll recall, we would get cases, and I'm not sure why. But they weren't necessarily a representative sample of the cases that the board receives. And I don't know that the board needed the subcommittee to view cases that were less problematic or less involved or had good enough expert witness reports. But the key to this, and I remember a couple committees with many of present audience commenting, I think was concluded that the process, there are a lot of stop points. The biggest stop point is the enforcement desk that gets the case, right? A lot is going to happen based on that person's taking it in direction A or B. And then when the in-house veterinary medical consultants read it. And then as far as we were tasked, the stop point of when it goes to the expert witness and what comes out of that product. And then the decision is made out of clearly the subcommittee's hands, as it well should be. But I think I understood the goal partly to be to get better reports and subsequently better trained expert witnesses. There was a lot of turnover. I don't know what the current situation is with experts, but my impression is it's probably difficult for the Veterinary Medical Board to get people to line up for that job and then stick around. You laugh. So I think it behooves the Veterinary Medical Board to pick good people, train them well, and give them feedback. And my impression is we're doing more of that.
Dr. Waterhouse, to your point, I think that if the intent of this committee was to look at the entire process, that's something that we have done with this committee. I think we can continue to do. We have changed a lot of how we process complaints, and we can start using the subcommittee to analyze whether or not that's resulting in improvements over when we compare to a case that we are implementing from start to finish versus a case that has been pending since 2013. I think that if you want to keep the committee going, we can definitely still use them in looking at the process as a whole. But to have measurable objectives, I guess, instead of just focusing on cases that are over 5 years after discipline.
I guess at that time, we were told that we were legally only allowed to look at closed cases.
That's all we've ever looked at.
Yeah.
Yeah, my question has to do with the necessity of redacting the information. That seems like a lot of work.
It depends on the cases that we give. If we, we can work through the logistics of how that would work for the subcommittee. So it wouldn't be a board member who are the ultimate decision makers.
Right. That
So they're not going to be the ones, so their opinions are separate, so I'm less concerned, but we would certainly work out our logistics to make sure that that's something that can be done.
And whatever the committee does, it has to be productive to the staff. So your description of what you could use or where you think the committee could keep working, that's very important. I think there's work to be done.
Other committee comments? Comments from the public? Before you start, Bonnie, I want to ask I'm just going to throw out a date. I couldn't tell you how close it was. Jessica mentioned 2013, but obviously 5 years ago they were old. So whatever cases that were reviewed however long ago, do you think, let's say take the last 5 years since 2015, you've seen any change in the reports from expert witnesses? And if so, how?
Okay, well, no. I mean, the sad truth is that I tried a case a year ago where your expert was awful. He was testifying against a doctor, and this is already resolved, a doctor who had done over 30,000 spays in his life, and your expert had done 2. He was an industry person. He was not a practicing veterinarian. The case took 8 or 9 days to finish because he went on and on and on and on and on. He didn't know the law. He didn't have the background. And that was just last year. So I'm up here to tell you that I'm actually happy to have a really good expert on the other side, but, because this case went on and on, it was just ridiculous. The other thing is you have experts who have old practice acts that they bring to the cases with them. They have, you can tell by the color, because the Practice Act comes out every year. So one of the first questions I asked the opposing expert is, do you have a copy of the Practice Act? What color is it? Oh, I have one from 2015, or worse, I have one from 2013, because there were all those changes in 2014. So I still think there's a lot of work to be done with your expert witnesses. You need to make sure that they're qualified. You need to make sure they understand the law. You need to make sure they're not opining on the law, that they're just opining on the care, and that they're going to be good witnesses. And I think that will cut down a lot on the money that you spend, because if the attorney generals have to keep amending the accusations because of the expert witness, that ultimately costs you a lot of money. And, at the end of the day, even though it's great, it makes money for me, I don't want to try a case for 10 days that should have been done in 3 days. So I still think there's a lot of work to be done with the expert witnesses, and I think that it would be a great thing if you could do that and tighten up what they're saying. I do think you're at a disadvantage. I pay my expert $475 an hour. I know you can't do that, so I understand, but I also understand that there are experts who feel strongly about testifying, working with you guys, and there are a couple that are really very good, and I think there are other people out there that are willing to do it for the money you're able to pay them, despite the fact that they get paid more by the other side. But I would strongly encourage you to keep on keeping on with trying to get the expert witnesses to where they're able to really opine in a good way in a court.
Thank you.
Grant Miller, CVMA. Just to comment a little bit on the history of where that subcommittee originated. Jessica, I appreciate that you had gone through a lot of the videos and kind of poured through them, but I do feel like there might have been a little bit of an element that you didn't discuss today relating to why that subcommittee was compiled. At the time that was taking place, there was a considerable amount of pushback from private counsel, like people like Bonnie, and from members relating to the validity of a subject matter expert. And the board, the Veterinary Medical Board at that time, thought that it would behoove the board itself to appoint a subcommittee to help legitimize and verify the opinion of the subject matter expert relating to the actual veterinary care. So set aside all the law stuff and all that legal stuff. Is this person who you've named as your subject matter expert, do they have their finger kind of on the pulse of where practice lies? So in relation to, running blood work prior to anesthesia, or in relation to, using a certain type of suture material, is their contention truly legitimate? Is it reflective of the standard of care in the state of California? And the concept was, if we had a subcommittee internally reviewing that, it doesn't matter how far back it was. It matters that the Veterinary Medical Board is continually monitoring itself to create some agreement after the fact, because of course, the best scenario would be, well, just have 3 or 4 veterinarians do it all real time, but that's obviously expensive and hard to, create consensus. So at least have them review it after the fact to say, are we still in the right place here? Is this moving in the right direction? Regardless of whether or not that subject matter expert still works today, it matters in terms of the record, because that legal precedent is set with each case and that needle continues to move. This was an internal check and balance on that needle. And I think it's been incredibly informative. I do like your idea, though, of having somebody review the entire process. However, with you at the helm, I don't think that the efficiency of the process needs to be questioned at this point. But there may be other parts of the process that might be able to be reviewed by somebody else. But I think that in terms of the subject matter expertise, there's legitimacy to having this internal review.
Yeah. So actually, I appreciate that. But I think then if it's to really gauge whether or not the subject matter expert has their finger on the pulse of what's really within the standard, then I think that we can have the subcommittee really look at what more of the criteria of the subject matter experts we want, and what tools we can provide them to make sure that they have a proper understanding of what is going on, because I think that we can do that just way early on in the process, because if we're doing it way after the fact, we've wasted all this time and money when we can figure that out now, train our experts better to make sure that they are properly up to the standard, and it's just before it snowballs down.
But to Dr. Miller's point, the example of was the correct suture material used, that applies in 2020 and it applied in 2012. And, qualifying the experts seems a big point. And the other thing I'd mention related to this is the subcommittee's work, however after the fact it was, did not and would not ever impact a current case.
Right.
And the things that we've gone over and some of the conclusions that we've come to over the last few years, I think one of the hottest topics, and we may not all still agree, but Val will remember, there was great discussion about should there be more than one expert on a case. As it is now, there's always one in-house veterinary medical board person who sees the case before anybody. And they write an opinion that's discoverable, and if it goes to a subject matter expert, that's discoverable. And you said it perfectly, Dr. Miller. You said having 4 people look at the case in real time is not just expensive, but it would be a pulling out your hair nightmare, because how are you going to get 4 veterinarians to agree on anything? So you have to pick better experts, train them well, and keep them up to speed, I think. Thank you. Other public comments? Committee?
Because I always have to say something. I think can we create criteria for an expert witness? I mean, is that possible?
Well, there are criteria.
I know there are criteria, but can we update that? Can we keep it, that's what I'm hearing, though, is some of those things, and just making sure that those things are constantly, based upon findings of the reviews. Maybe there's other things that need to be updated in that as well. I know there's criteria. I've gone to the expert witness training.
You know
I've
what
done
they
it.
are?
No,
To
I don't
be an
remember
expert
them.
witness in California, what's required is, you'll correct me, but I think it's valid license, no disciplinary action, 5 years experience. That's a pretty low bar.
Right.
And so with that, you have a very difficult time finding experts, or am I wrong? Are they waiting outside somewhere?
They're lining up.
Yeah,
I don't have the document with me, but I can get you a document that we introduced in that case I just referred to, that was brought to me by my expert, which was a document used in medical cases to qualify experts in court. And we actually use that document to try to disqualify your expert in that case. The judge went so far as not disqualifying him, but she did say that my expert had a lot more expertise. So we basically
You
won,
would agree
but-
that it's different in the human world?
No, it's not. Because these criteria, they were a list of things that really had to do with, in this particular case, had to do with how many of these procedures have you done? When was the last one that you did?
Yeah.
And that were the questions that were asked in a medical procedure to qualify an expert. I used that, and the judge allowed me to use it to question your expert in that case, who clearly did not have the expertise. So I think I can find that document and I can give it to you, and you can actually use it. It's not a legal thing that can only be used with medical. It's a list of questions to qualify an expert.
I stand corrected. I don't mean that document wouldn't be bad and isn't the case, but what I mean by it's different in the human world is there are people that are full-time expert witnesses. That's what they get paid to do, and the field is bigger. The pot is just bigger. The money is bigger. So they're going to be better experts.
No, but I think that what I'm saying, though, is these questions made sense in this case.
Understand.
Because they asked, how long have you been licensed? How many of these have you done? How many of those have you done? How many actual dogs have you ever provided vet care to? I mean, it was a really good questionnaire that I'd be happy to provide.
And I think that's important, and honestly, the subcommittee doesn't know the answer to those questions for, frankly, any of the reports that we read. The bios of the expert didn't come with at that time or since, so that's, I think Bonnie makes a good point. Christy?
I think that's what I'm saying, is like when they're reviewing it, it's almost like a checklist for themselves, questions they should be answering. Can I legitimately be able to answer these questions or review this case? And it's a checklist for themselves to be able to provide expert testimony, and it's saying, how many procedures have I done? What have I done? What qualifies me as an expert in this case?
And the process is supposed to be, when the expert gets assigned the case, they are instructed to read it, review it, and if they feel they aren't qualified, they are supposed to send it back and say that, but that never happens. It just never happens.
That's the.
We wouldn't have known because we don't get that list of qualifications, we don't get the bio of the person. And that also wasn't the assignment, you know, it wasn't our assignment to qualify the expert witnesses. But the process clearly could be improved even now. So,
I just wanted to clarify, when you had talked about the process and how enforcement cases are being reviewed by the in-house consultants, they're writing up a full report, and then
No.
it's going to another subject, well, that's not what we're doing.
no, that
Okay.
wasn't what was done then either. No, if the number of complaints is up to, last number I heard was 1,900.
Yep, we're almost at 2,100 right now.
Two,
I have 4 analysts.
okay, so 21 divided by 4. 600 some cases apiece, and I don't know if they all work full-time. I know they all don't. Clearly, they can't write a report on every case. The best they can do is read those 600. And then we saw some reports from the in-house experts over the course of the reviews, certainly. But I lost my train of thought. I guess it was it was our discussion that put this on the agenda that I thought we should present to the committee, this is where we were, this is where we are, and should we continue on same path or any path? And what I'm hearing is we should continue on some path, but I'm not sure exactly what it is.
Any path that's going to make it more efficient and better for them without creating more work, because obviously that's the thing. Anything that's going to help get the cases through, because it can't inhibit the process at all.
And also make sure that there's measurable objectives that we're doing, because even if it started with a great intent 5 years ago, Bonnie said they're not improving. They're not, I can tell you that now. That's clearly, we need to try something else, but with the same, we can still use the same committee. We just have to be able to improve and measure the improvement and hold the team accountable to make sure that it is getting better.
So should we have the audit subcommittee meet with Jessica and her enforcement team, or whoever, just Jessica, and just try and make a plan for what it should look like going forward?
Okay, I can live with that. How about a teleconference? We don't need to meet necessarily, do we? Yes, Christy.
Jeff, you're leaving in June, right?
Yes.
So do you want to maybe consider appointing one of these other fine doctors? No offense.
We will have to do that.
Yeah, just wanted to, before you get started, this ball rolling, you might want to consider that.
Good point.
I know it'll disappoint you, but.
And we don't have to do that right now. We can do that after the fact. Okay, but we've concluded that this subcommittee isn't closing. Okay, good. I think. Agenda item number 7, future items, committee priorities, meeting dates. Jessica?
So I think that this MDC has tackled a lot of assignments that the board has given them. Depending on what comes out of tomorrow, they may or may not give the board more assignments. So I don't have anything pending except the caveat for the use of cannabis, not separate from the guidelines, depending on what happens with the cannabis legislation. I think that's the one outstanding item right now.
And currently, we're working on the premise that that subcommittee persists and is following SB 627. And there was a SB 153 that passed, I guess, related. Okay, meeting dates. I've got April 22nd, a Wednesday, here in
Yep.
Sacramento.
No, Fresno.
Well, so it currently says Fresno. We're doing a cost analysis of Fresno right now. Dr. Waterhouse did get us a really good deal on having it at the Fresno Zoo. That would be considerably cheaper than any hotel. My concern is access to Fresno. We looked at a lot of flights, especially people coming from Southern California. It doesn't fly Southwest. It could take a member up to 8 hours and multiple layovers to get to Fresno. And plus, it's everybody except for, I believe, Dr. Waterhouse to travel, and it's expensive.
There are direct flights between LA and Fresno.
Oh, I was looking at from Santa Ana, but so we're looking at it. I'm just concerned about access to a meeting, especially given the current atmosphere of what's going on. I just am concerned, but I think it's something that the board just needs to discuss and maybe get input from people who would otherwise attend.
I came from San Diego in October of 2015, and you're right, there were no direct flights, and it ain't easy going through LAX.
There are direct flights between San Diego and Fresno.
Well, there weren't in.
Maybe not them, but there is.
There weren't in 2015.
I believe Alaska now has.
Yeah, Alaska does.
It was Alaska that I flew, but I know it wasn't direct. Okay.
I guess it would be helpful since this would impact the committee as well. Do you have any concerns with Fresno, or are you okay with having it in Fresno?
I'm completely okay with
And my opinion is I'm completely okay with Sacramento.
Yes,
Can we ask Kevin?
Yeah, could I ask the public to comment on that? Well, step up to the table, please.
Nancy Early, California RVT Association. I would just like to say that getting to Fresno was rather difficult for people who don't live in the area.
Thank you. Anybody else?
The zoo is very nice.
I'm sure I like Fresno. I wish I could live closer. Okay, I have one other item, future agenda item per what Christy pointed out. I will term out in June, so the next meeting in April will be my last, so we will need to vote on a new MDC chair at that time. So we'll have to send out.
Yeah, so we also will have to do recruitment, and I plan to send that recruitment notice out this month to start getting some applicants to apply and have the board appoint them at the next meeting.
Dr. Sullivan.
I have another item, if it's appropriate. I saw in the minutes, I believe this is the board minutes of discussion on tiered premises permits fees. And if the board is overworked and despondent, they could refer that back to us.
We've only worked on it 100 times, so.
Not the premise permit fees.
Yeah, not the fees, but.
My thinking is if it's tiered, maybe we can eventually get some relief for the RVTs.
Okay. I will mention that in my report. Any other items for future agenda? Any other public comment? Okay, may I have a motion?
Move to adjourn.
Dr. Laz, seconds.
You don't need to do this, but it's not.
Oh, no? Thank you, all.